Mention an appellate matter. Lordship, I know your Lordship has given up the determination, but in that muscular dystrophy matter.
We'll do something.
Lordship,
Because Justice Sen is not available today.
Lordship, last time, my Lord.
No, technically it has gone there. You can mention saying that the matter was substantially heard. Then His Lordship will do something. Okay.
Your Lordship.
You be rest assured something will be done.
Because I've also done, your Lordship had required me to do the.
You go and mention tomorrow. His Lordship is not available today.
Lordship.
Tomorrow you do.
May I be permitted?
May I be permitted to mention this matter for filing this appeal without certified copy? My lord, urgency is that, my lord,
Write up the order.
my lord, order was passed on 29th November 2024. I applied for certified copy on 4th December 2024. My lord, the order was served last week, my lord.
We will direct them to issue certified copy today.
My lord, the urgency is there, my lord.
November order.
Yes, yes.
We will ask them to.
Yes, yes. That will
So
be
if you have the certified copy today, then you will save on limitation.
Yes, that's I am within the limitation. But as the certified copy has not been supplied to it, the appeal cannot
tomorrow they will issue.
My lord, deeply obliged. And another thing is, my lord, the item number 93 of this today's list, it is pertaining to the motion, but it has wrongly appeared under the
appellate side matter.
Appellate side matter.
Let us see. We'll take note of it.
Yes.
My lord, may I be permitted to mention, my lord, one application in connection with an appeal, my lord. It's a new matter, my lord. So, my lord, contempt proceeding has already been initiated after I filed the appeal, my lord.
May I be permitted to mention one appellate side matter for inclusion?
What is the urgency?
My lord, the contempt proceeding already been issued by the
service matter.
Service matter, my lord.
Fresh application. Fresh matter.
Deeply obliged.
My lord, in spite of death of my mother, I Shakti Shankar Bakchi, I appeared before Honorable Justice Sabbar Rushidi bench. Mention, please consider for time or fixed the date. Did not allow my mention and regular harass, inhuman manner and biased decision. Regular, I from Bahrampur to Calcutta, up down 400 kilometers run. Matter did not any submission recorded and without cost title order passed. So my humble request to release the matter for assign any other bench.
Unless a judge releases, we can't. You are not temperate in your language. You are not observing the decorum of the court. You are abusing the judges.
My lord.
You have impleaded me as a first respondent in a case. You have arrayed me as an accused. So you have no sympathy. Done.
My lord, please consider.
Yes, sir, we have considered. Thank
Lordship,
you.
I'm petitioner in person. My wife is the victim.
Yes, we remember your matter.
Yes, and this matter has been assigned by Justice Mantha again to you. The matter was for 1.5 years.
You give the letter. Let us see.
Your Lordship, can I have it matter heard by
you? Give the letter. You please hand over the letter. Let us take the file and see. Yes, madam.
May I mention item number 76 of today's list for upgradation, Lordship?
First today let us
Lordship,
start.
the matter is very urgent, Lordship.
Very urgent, madam. So we will start the list. Let us see how we proceed.
May I give the mentioning slip, Lordship? Kindly, Lordship.
For your satisfaction, we can take.
Because if this matter is not taken up, Lordship,
all right,
urgently, Lordship.
My lord.
The appeal will.
Yes, sir, Mr. Sinha.
My lord.
Please unmute. Please unmute.
May I mention with the leave of my lord, Miss Justice Chatterjee, in a matter in an administrative side. My lord, it's unfortunate the probate order was passed granting probate on January 15, 2025, but I have not still handed over with the copy of the original will and probate.
Can you ask your junior to give a letter to the OSD?
My lord, already given. My junior is present in court. He is handing over.
Don't give it to the OSD.
My
He will hand it over. I'll look into it.
My lord.
Yes, sir. We are on the list. Sir.
Original sale monthly list, item number 1 and 2.
1 and 2 and 3, my lord. These are identical issues, my lord. These are related.
We already decided that issue.
No. Actually, the Mr. Parsi came on Friday, but anyway.
What to do?
His humble request, my lord, kindly fixed on 20th June, sorry, 20th June. It is a Friday, my lord.
All right.
My lord.
At the
And
request
at
of
the
the
same
learned-
time, my lord, when your lordship passed the item number 3's order, last order, your lordship direction to hand over all the paper book of the tribunals. We have brought the copy of the tribunals for your lordships, if your lordship can.
No, we will take it on 20th.
Okay.
You please.
But I
serve it
already
on-
handed over to them. Kindly record this also. I already handed over. My lord, kindly record it.
All right. The copy of the paper book filed in ITA number 62 of 2024 has been served upon the learned advocate for the appellant, who has acknowledged the receipt of the same. At the request made on behalf of the learned advocate appearing for the respondent assessee, list on 20th June. What you do is, for 3 or 4 days before that, you verify from the court officer, then inform Mr.
Yes.
Percy.
It will be in the same position. Same. Great.
Item number 4.
They want to modify, stay the operational. Where is Tapan Banja? Is not here. 60. 16. Pass over, take along with item 16.
Item number 5.
Is Avra Mazmundar here? He had appeared before the single bench. 148 AB, AD order. Nobody represented the department. It's. Writ petition was being dismissed on the ground. Appellate remedy is available. But their contention was that a reply was given to 148 AB that was not considered. Request for adjournment was made that was not addressed. Mechanically, order was passed. But what they say is, they filed a reply. The reply was not considered. Then a video conferencing hearing was fixed, in which they appeared. And verbally, the fifth respondent assessing officer wanted some clarification. But the assessee could not upload the clarification. Therefore, they submitted a reply along with an adjournment on the portal. Without considering that 148 AD has been passed.
My lord, only one thing subject to lordship correction, my lord, what may I understand, my lord. Now, my lord, your lordship can, my lord, you wanted back the matter to the assessing officer. But problem is that, my lord, I don't know, my lord, after 148 AD order, whether, my lord, the assessment is already passed or
Yes,
not.
passed.
That is assessment passed.
Your Lordship, Mr. Obro Mojumdar is on his legs before court number 26.
You start.
May we please, if your Lordship would be pleased to make it not to.
Why? See, your petition was dismissed on the ground of alternate remedy. Correct?
Yes, Your Lordship.
Take a deep breath. We could have sent it back had you approached the court immediately after 148 AD. But thereafter, the assessment order has been passed.
Your Lordship, the assessment order even suffers from certain infirmities. My senior would be.
You tell what is the
looking to
infirmity,
submit.
by then he will join you. What is the answer?
Even if, my lord, after passing the assessment order, my lord, I don't know, my lord, when the, my lord, writ petition has been moved, because, my lord, there is a time limit also for filing this.
Date on which the writ was affirmed. 12th July.
And, my lord, assessment order passed.
22nd March.
That is also, my lord, barred by limitation.
Assessment order took on page 58. If your Lordship would kindly take page number 64, your Lordship.
64.
64.
Paragraph 5.1. You share that paper with Mr. Soman Bhattacharya. You read 5.1, the last 4 lines. That's their case. The documentary evidence regarding the copy of exemption certificate 1023C6, which was required and which may be approved by PCIT, and requested to submit point-wise reply, which was highlighted in the show cause notice. Assessee was given time till 14/3. However, the assessee did not furnish reply. If you come to their grounds, in the writ petition as well as in this appeal, they have raised the point. Please come to page 7, ground number F. Middle of that, your appellant petitioner appeared and discussed the case wherein fifth respondent verbally gave a requisition to submit clarification, but without providing any opportunity on the income tax portal. The appellant wanted to file those clarification on the portal, but could not find on portal place to upload. Therefore, he opted for adjournment on March 14, but also submitted his reply along with the adjournment on the income tax portal. Sorry.
petition file করেছিল।
Points which you have raised, challenging the 148 AD order.
I'll be deeply grateful, Your Lordship.
Well, only Your Lordship kindly note that this is exceptional circumstances because
it's an educational society. There was some mismanagement, etc., and the school was taken over by this society. They have got the 1023.
only purely question of violation of principle of natural justice and exceptional. Because it will take the SSC again and again this order will be placed.
Please come. We have heard you are Alisha Das, no?
Yes, Your Lordship.
We have heard Ms. Alisha Das, learned advocate, appearing along with Mr. Abra Mazmundar, learned advocate for the appellant. In the this intra-court appeal by the assessee is directed against the order dated 14th November 2024 in WPO 710 of 2024. The appellant had challenged the order passed by the assessing officer under section 148 capital A within bracket small d of the Income Tax Act 1961 within bracket the Act. Where is the 148 AD order? Page number.
That's from page 21.
21, page 21.
Challenging the order passed under section 148 so and so dated 28/3/2023 and the consequential assessment order dated 22nd March 2024. The learned single bench was of the opinion that the appellant should exhaust the appellate remedy available under the Act and accordingly disposed of the writ petition. It has been recorded in the impugned order that none appeared for the respondent, Income Tax Department. We have directed Mr. Soman Bhattacharjee, learned Senior Standing Counsel for the Income Tax Department, to appear on behalf of the department by accepting notice, and his appearance shall be regularized by the department. There is a delay of 19 days in filing this appeal. Considering the facts set out in the application in GA 1 of 2025, we find that sufficient cause has been shown for not preferring the appeal within the period of limitation, and accordingly, we exercise discretion and condone the delay in filing the appeal. As could be seen from the memo of appeal, as well as the grounds raised in the writ petition, the appellant did not question the order passed under section 148 capital A within bracket D, as well as the assessment order under section 147 on the merits of the matter, but solely on the ground that it is in violation of the principle, it has been passed in violation of the principles of natural justice. Therefore, we refrain from entering into the merits of the matter, and we have heard the learned advocate appearing for the appellant assessee, as well as the learned advocate appearing for the respondent department. As pointed out above, the short issue which falls for consideration is whether there has been violation of principles of natural justice, and if it is found so, then it would fall within one of the exceptions which would entitle the court exercising jurisdiction under Article 226 of the Constitution of India to interfere with such orders, despite there being an appellate remedy provided under the Act. The undisputed fact, the facts which could be culled out from the documents annexed to the state petition are that the assessing officer issued notice under section 148 capital A within bracket small b of the Act dated 2/3/2023 along with an annexure, and was of the prime facie view that an amount of rupees 3,26,10,140 is the income of the assessee, chargeable to tax, represented in the form of assets, has escaped assessment or is likely to have escaped assessment for the assessment year 2019-20. The assessee submitted its reply. Its reply. By a reply dated October 17, 2023, which was uploaded in the income tax portal. The appellant could state that the change of identity and PAN number of the appellant and also also uploaded various documents to establish its case, and also mentioned that the return was filed on September 5th, 2019. And therefore, the information received from the second respondent, namely Income Tax Officer, Ward 1 within bracket 1, exempt, Calcutta, is incorrect. The appellant thereafter, the respondent number 5, namely the National Faceless Assessment Center within bracket NFAC, issued notice under section 142 within bracket 1 dated October 26, 2023, for which the assessee submitted reply on November 7, 2023 along with the requisite documents, which is stated to have been uploaded in the income tax portal, and the assessee has also given the acknowledgement number. Subsequently, a show cause notice was issued on March 4, 2024, calling upon the assessee to submit their response by March 8, 2024. And the assessee would submit that within the time permitted, they uploaded the reply on March 7, 2024, in which detailed discussion on merits was made and all queries sought for were fully explained. The assessee received an intimation dated March 8, 2024, that the assessee will be afforded an opportunity of hearing through video conferencing, which was fixed on March 12, 2024 at 4 p.m. The assessee appeared in the video conferencing meeting, and it is stated that certain verbal clarifications were sought for by the respondent number 5, for which the assessee wanted to submit documents and clarification, but their case is that they could not upload the same in the income tax portal. Therefore, by letter dated March 14, 2024, they opted for an adjournment. The assessee's further case is that without considering the submissions made by the assessee, by a letter dated March 14, 2024, And the explanation which was offered during the video conferencing meeting, the respondent number 5, no, the assessing officer proceeded to pass an order under section 148 capital A within bracket small d of the Act dated 28th March 2023. Subsequently, the assessment order was passed, and challenging those orders, the writ petition was filed. On perusal of the assessment order, we find the facts as stated by the assessee are not much of the facts stated by the assessee, as noted above, is not in dispute. This is evident from paragraph 5.1 of the assessment order dated 22/3/2024. The assessing officer would admit that the assessee was granted time till March 14, 2023, but did not furnish any reply. Whereas the case of the assessee is that they could not upload the necessary documents, and therefore they made they submitted a request for adjournment along with a brief explanation. And therefore the assessee would submit that the finding of the assessing officer that no reply was filed by the assessee till March 14, 2023 is factually incorrect. Thus, considering the peculiar facts and circumstances of the case, it appears that the assessee did not have sufficient opportunity to put forth their submissions in the form of documents to establish the merits of the matter. It is not as if the assessee was not diligent in contesting the matter, as could be seen from the various replies submitted by the assessee, and also the acknowledgement of the e-proceedings. Which are enclosed in pages 56 and 57 of the stay application. Therefore, we are of the view that one more opportunity can be granted to the assessee to go before the assessing officer, submit the documents and clarification, so that the assessee has the satisfaction of placing all records before the assessing officer, and that the assessment can be redone. At this juncture, we take note of the apprehension expressed by the learned senior standing counsel for the department that this order should not be taken as a precedent in all cases, more particularly when the assessee did not approach did not file the writ petition within the period of limitation provided for filing a statutory appeal before the Commission of Income Tax Appeals. However, as noted above, the facts of the case are peculiar, and moreover, the assessee is stated to enjoy the registration under section 10 within bracket 23 capital C of the Act. And they had also filed the copies of the deed of trust, certified copy of the registration under section 12 capital A and section 80 capital G, and all other details as has been noted by the assessing officer himself in paragraph 4.5 of the assessment order dated 22/3/2020. Thus, for the above reasons, we are inclined to interfere with the order of assessment and remand the matter back to the assessing officer for a fresh consideration. Accordingly, the appeal is partly allowed and the assessment order dated 22/3/2024 is set aside and the matter is remanded to the assessing officer for fresh consideration. The assessee is directed to place all documents, including their written submissions, before the assessing officer within a period of 3 weeks from the date of receipt of the server copy of this order, after which the assessee shall be afforded an opportunity of a hearing through the virtual mode and the assessment shall be redone in accordance with the law. The assessee is at liberty to canvass all grounds, including the grounds which they have raised, challenging the order passed under section 148 capital A within bracket small d of the Act. It is made clear that this order has been, this judgment and order has been passed considering the peculiar facts and circumstances of the case and not to be treated as a precedent.
I'm so grateful.
Only one thing, assessee will participate and cooperate with the proceedings.
Needless to state that the assessee should cooperate in the assessment proceedings and no request for adjournment shall be entertained.
Only one thing,
Undo.
may I subject to correction, page 64, para 5.1, it has been gone in the assessment order. The assessee was given till time 14/3/2023. That will be not subject to correction of 14/3/2024 because there is a mistake in the
I said
order.
2024 only.
Yes, because the time has been given to the assessee file reply till 14/3/2024.
2024.
Yes, because the assessee also submitted his adjournment on 16/3/2024. Thereafter, assessment order passed on
22nd.
20. Yes, Milord.
Next.
I'm deeply grateful to your lordship.
Item number 6.
Well, I'm told that in the item number 5, Mr. Tilak Mitra is appearing on behalf of the revenue.
Oh, so therefore your name will strike off. Huh?
Yes, Mr. Mitra's name will be
You can be along with him? No.
Yes, along with.
So then that line can be struck off. We have said no, nobody appeared for the department, etc. In that that line you strike off and say we have heard Mr. Tilak Mitra, Learned Senior Standing Counsel, along with Mr. Soman Bhattacharjee, Learned Senior Standing Counsel for the respondent department.
And my appointment with that line also be not given.
The appearance of Mr. Soman, both the learned regulars.
No,
both. Next.
Item number 6.
My lord, Mr. Tilak Mitra is appearing on the matter as appellant.
273 days. Yes, sir.
It can be condoned, my lord. But
what is the matter?
Technical point is there. The tax effect is less than 2 crores.
Where do you get it, sir?
My lord, at page 22, para 4, though they have invoked circular number
exception.
5, but it will not come under that because that circular has been notified subsequently, subsequent to the filing of the appeal.
Your appellant state that aggregate tax effect is 99,11,160. But the present case being a case of organized tax evasion activities within the meaning of clause so and so.
Share capital of 3 crore was ordered. 3 crore
Now,
order was
circular is dated 15th March 2024.
My lord, there in assessee's own case, my lord has passed this order. This is a common order.
Oh, this order passed by the tribunal is a common order.
Date of filing is different.
Impugned order was passed by the tribunal on 22nd September. Certified copy received, the appeal was so and so, but the same was filed. But here on what date the appeal was filed?
Lord, it was filed on 4th of December 24.
The appeal ought to have been filed. You give the dates, within what time they should have filed the appeal?
Lord, condoning
Same facts.
5-3.
Huh?
Same facts.
We have heard so and so, so and so. There is a delay of 273 days in filing the appeal. As the explanation offered is acceptable, the delay is condoned. Application in GA1 of 2025 is allowed. This appeal by the revenue under section 260 capital A of the Income Tax Act 1961 is directed within bracket the act is directed against the order dated 22nd September 2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata in ITA number 625/K1/2023 for the assessment order 2012-13. The order passed by the learned tribunal is a common order in two appeals filed by the assessee for the assessment year 2012-13 and 2013-14 in ITA number 625 and 626/KOL/2023. The revenue had filed an appeal against the order passed for the assessment year 2013-14. Revenue had filed an appeal before this court against the order passed by the learned tribunal for the assessment year 2013-14 in ITAT number 192 of 2024, in which the effect of the circular issued by the CBDT dated 15th March 2024 in circular number 5 of 2024 was discussed, and it was held that the appellant department cannot rely upon the same, and consequently the appeal was dismissed. The operative portion of the order dated 7th August 2024 in ITAT number 192 of 2024 is quoted here and below.
My lord, it is my
Thus, following the above order, no, in the light of the fact that an appeal filed by the revenue on the very same ground in respect of the common order passed by the tribunal has already been has been dismissed by the above order. Following the same, this appeal also stands dismissed.
My lord, it is my bounden duty to point out there is small contradiction in the order, earlier order. My lord has stated that we find regions given are acceptable and delay has been properly explained.
The last line, I think we corrected it subsequently. Sir, you don't expect this. Only this. Next.
Item number 7.
Not in this matter also are led by Mr. Tilak Mitra. No, item number 6. Item number 6.
6. Whatever is appearance.
In item
138, yes, can be condoned.
In item number 7, my lord, I'm being led by Mr. Abhritosh Majumdar, senior advocate, Your Lordship. Carolina Foods এবার খোল ফেরা।
এই তো আজকে ওদের নামটা দেবে তো দেখে
It is CAT appellants are high.
So. Supreme Court, sir.
Yes, Mr. Soman, what is?
Well, I'm led by.
Oh, yes. Two issues. What is the effect of merger, demerger? Second is time limit for filing the return.
Yes.
They relied upon this Supreme Court decision in Dalmia Power, saying that 153, it has a non-obstante clause, no?
Yes, it covers it. So it's a
153A.
So that is indifferent. So that is also very good. So these are the other things.
I know. Maybe. Because I'm doing a matter for Dalmia.
Miller, the first order of merger was Miller given effect from 1st April 2014. Thereafter, the demerger took place. Miller, the subsequent date, that is on.
Give the date again. First.
1st April 2024.
14.
2014. Miller, when all the 6 companies were merged together. Now, Miller.
And your lordship will find the exact list of dates at page 36. That's part of the CIT appeal order.
That will be easier.
That will be easier.
Merger from Calcutta High Court, effect from 1/4/2030.
Yes.
Revised merger order, demerger order passed by Calcutta 7 from the Penguin Trading, again with effect from 1/4/13. The effective date was also return of income was filed by us. After the order of the settlement commission,
Nothing remains, my lord.
Nothing remains.
Nothing remains.
Please come. This we have heard. There is a delay of 138 days. You condone the delay. Para. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961.
Settlement commission order হয়ে গেছে।
অর্ডারে তো এটা দিয়েছে অর্ডারে তো কেন বেনিফিটটা বলেছে ঠিক আছে কোনো লস হচ্ছে কিন্তু লসটা আমি ক্যারি ফরওয়ার্ড করতে হবে অর্ডার
করেছি অর্ডারটা
The 260 capital A of the Income Tax Act 1961, challenging the order dated 5th March 2024, passed by the Income Tax Appellate Tribunal B Bench Kolkata in IT SSA number 118/KOL/2023, CO number 15/KOL/2023 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page 6 and 7, sir. 1 A, B, C, D. We have elaborately heard the learned advocates for the parties and carefully perused the materials placed on record. The revenue is before us, challenging the correctness of the order passed by the learned tribunal, allowing in dismissing the revenues appeal and allowing the cross objection filed by the assessor. The following list of dates and events would suffice to take a decision in the instant appeal. The assessee was merged with Messrs. Penguin Trading and Agencies Limited, along with 5 other concerns of the group, by order of merger passed by this court on 24/12/2014, and the merger was to take effect from 1/4/2013. Subsequently, this court passed another order of revised merger on 19/3/2016, by which the assessee was demerged from Messrs. Penguin Trading and Agencies Limited, again with effect from 1/4/2013. After receiving the demerger order, which was effective from 1/4/2013, the assessee filed its return of income for the assessment year 2015-16 on 17/10/2016. Subsequently, intimation under section 143 within bracket 1 of the Act was issued by issued on issued for the return of the income filed, issued on 24/10/2016 for the return of income filed on 17/10/2016. While so, subsequently on 27/4/2017, a search/seizure and survey proceedings was carried out at various business and residential premises of Batwal Group, and the assessee was one of the group concerns of the said group. Pursuant thereto, notice under section 143 capital A was issued on 2/11/2017, and in response to the same, the assessee filed the return of income on 2/12/2017. Messrs. Penguin Trading Agencies Limited applied before the Settlement Commission on 27/7/2018, and the Settlement Commission has passed an order on 25/6/2019 under section 245 capital D within bracket 4 of the Act, and it was held that the losses and expenses of the assessee for the assessment year 2015-16 are allowable in the hands of the assessee, and a particular sum of money towards item debited in the books of Messrs. Penguin Trading and Agency Limited, included in their return, were added back, and direction was issued to the assessing officer to consider the said losses and expenses in the hands of the assessee as the assessment of the assessee under section 153 capital A was pending as on date. The appellate authority, namely the Commission of Income Tax Appeals, while passing the order dated 6/3/2023, has noted the above factual position. I think relevant para will be page 49, last paragraph. Correct?
Yes, ma'am. Your lordship may also kindly take page 44 of the CITA order. I mean the running page, I'm sorry. This is excerpts from this ITSC order. Now your lordship will kindly take 6 point.
After that.
Yes, after that there is a conclusion.
Page 49.
Yes, absolutely.
Correct?
Yes, absolutely, madam.
And held as follows, sir. Page 49, one paragraph till page 50.
#51, my lord. 51, the third new paragraph in the present case. That is why the return was also filed belatedly.
Page 51. I'll mark that paragraph in place. After coming to the above conclusion, the CITA held that the assessing officer was asking the assessee to do something that was legally impossible, and therefore the same cannot be approved. The CITA took note of the decision of the Honorable Supreme Court in Marshall Sons and Company. Sorry. Took note of the decision in Pentamedia Graphics Limited. Have you got the judgment copy, sir?
Yes, yes. Pentamedia, Justice Chitra Venkataraman.
No, this is just.
For the cost title, I want.
Yes.
After taking note of the decision in the case of Pentamedia Graphics Limited versus Income Tax Officer 2012-20 taxman.com 755 within bracket Madras, in which the court took into consideration the decision of the Honorable Supreme Court in CIT versus Sun Engineering Works Private Limited 1992 198 ITR 297 within bracket SC. And also the decision of the Honorable Supreme Court in Marshall Sons and Company India Limited versus ITO 1997 138 CTR within bracket SC within bracket 1, which dealt with the case of amalgamation, particularly with reference to the effective date from which the amalgamation is to take place. Therefore, the CITA held that the only course open to the revenue would be to act as per the scheme of amalgamation approved by the High Court, effective from the appointed date, and the taxing authorities are bound to take note of the state of affairs of the assessee as on the appointed date, and the return filed beyond the due date of filing the revised return of income cannot be ignored on the strength of section 139 within bracket 5 of the Act. With the above reasoning, the appeal filed by the assessee was allowed. On what ground you file cross objection? That is not on this ground.
No, that is not.
Because that is also disposed of. The revenue carried the matter on appeal before the learned tribunal, which took note of the reasoning given by
I just checked that.
by the CITA and approved the same. In this regard, it would be relevant to take note of the decision of the Honorable Supreme Court in Dalmia Power Limited versus ACIT 2019 112 taxman.com 252 within bracket AC.
Yes.
Wherein the appeal filed by the assessee was allowed and the order passed by the single bench. Was affirmed, wherein direction was issued to complete the assessment for the in respect of the said assessee for the relevant assessment year after taking into account the scheme of arrangement and amalgamation as sanctioned by NCLT within bracket in the said case.
The doctrine of impossibility.
In page 59, you take para 7.
Para 7.
This extract is from this Shrikant Mohata.
Shrikant Mohata.
That you are carrying?
Yes, we have got. We have also got Dalmia Power, if your lordship want. Dalmia Power.
Regarding 153A and 139. That is, I
Dalmia
think,
power, if you lordship kindly takes paragraph 7, so your lordship will find 139.5 has been dealt with of Dalmia.
paragraph 7.
And here it is para 70. Dalmia 7, so Dalmia is here, so this is done.
Dalmia have handed up.
For you, sir.
On one copy, I'm sorry, I'm so sorry, man.
So Dalmia is a para 7. In case
Which
you want,
paragraph?
Para 7 of Dalmia.
Page,
my lord. It is page 355. This ITR we are. इसमें क्या है 17?
notice saying basically, sir, that if I file a return in response to 153 notice, then that return has to be considered and you cannot discount claims because it is a return being filed in return. So
wherein, so this is that Dalmia power.
Okay.
para 70.
At this juncture, it would be relevant to take note of the observations of the Honorable Supreme Court, the effect of section 139 within bracket 3 and section 153 capital A within bracket 1. From para 5 it is better. 5, 6, 7, 8, sir. Page 350.
Shall we hand up Srikant Mohta also?
Srikant Mohta.
Return notice with para 70.
Para 17, man.
Identical issue was considered by the Honorable Division Bench of this court in the case of Srikant Mohta versus Commission of Income Tax 2019 414 ITR 270 within bracket CAL bracket close, wherein it was held as follows. Para 17, sir. In the light of the above stated legal position, we find that the learned tribunal was fully justified in dismissing the revenues appeal. For the above reason, this appeal stands dismissed and the substantial questions of law are answered against the revenue.
There is a delay also.
Delay we have condoned.
Today is Mr. Datta's birthday.
Oh, very many happy returns. How young are you today?
He's as young as me.
Item number 8.
But I am appearing for. Well, I am appearing for the respondent. There is a delay of 200.
Where is Mr. Aryak Dutt taking you for lunch today? You have to take all your friends. 229 days.
229 days relevant. I am not opposing.
Then
kindly fix the hearing of admission in some other day.
All right. Sir, delay condoned, sir. Say that explanation satisfied, blah, blah, blah. Delay condoned. Next.
Item number 9.
No, I am appearing with a delay of 117 days, 117.
What is the matter? Individual assessee.
I tell you, Lordship. But here, for the first time, Lord, the additional ground was taken with the tribunal. Lord. It's a question of a long-term capital gain. This is a penny stock matter, Lord. Subsequently, Lord, before the tribunal, for the first time, Lord, the judicial points was taken, Lord, as section 120 was taken for the first time. Lord, may I just indicate, Lord, one thing, Lord? Lord,
where is the bar for doing?
Lord, section 124, subsection 3 is the bar, my Lord, which says, my Lord, within 1 month, he has to raise this question. He has raised, my Lord, for the first time before the tribunal.
No, we have decided this issue, no?
Yes, we have got the judgment. Bhagya Lakshmi conclave has been referred to and relied on by the tribunal in the impugned order. And your lordship, this Bhagya Lakshmi conclave was carried to this honorable court. Your lordship was pleased to deliver this judgment. Identical issue. না ভাগ্যলক্ষ্মী কমপ্লেন ভাগ্যলক্ষ্মী and ধনলক্ষ্মী দুটো আছে kindly take the questions it's instruction 1
What is that instruction 1? Which
and
permit?
instruction 1 your lordship will find being quoted in the tribunal order it is the monetary limit
Okay.
that above 20 lakhs some officer below 20 lakhs some officer that
No, what he says is, I mean, Mr. Doria's submission is that this ground ought to have been urged within 60 days or 30 days.
30 days. Lordship, kindly see section
That
124
is to be
subsection
decided.
3, my lord.
That issue, my lord, I tell your lordship, that issue your lordship has decided cosmetic. Your lordship has decided, moreover, in this case, my lord, the officer who issued the 143(2) notice, the jurisdictional notice, that officer was not competent to do so. It was not a case of change of jurisdiction. So, my lord,
Inherent lack of jurisdiction.
And my lord, the explanation to section 120 takes care of that situation.
That is explained in the tribunal order itself.
That is explained in the tribunal
Three
order.
matters we decided this issue.
Cosmet traders.
You give a soft copy.
We'll give a soft copy. Cosmet na
But we
Cosmet.
considered that explanation also.
Kindly take দেখি one section বইটা কোথায় kindly take my lord assigned in accordance directions or as the board in accordance with such directions as the board may issue. The direction would mean, my lord, the instruction number 1. Instruction number 1, my lord, define the jurisdictional limits of the officers. So in terms of the instruction number 1, my lord, the ACIT could not have passed the assessment order. Only the ITO could have passed the assessment order as the assessee declared its income as nil income.
And that is totally in the tribunal as explained in the.
Sir, please come. There is a delay of 117 days in filing the appeal. As the explanation offered by the appellant department is found to be satisfactory, the delay in filing the appeal is condoned. Application in GA1 of 2025 is allowed. Para. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated April 8, 2024 passed by the Income Tax Appellate Tribunal B Bench Calcutta in ITA number 2416/KOL/2017 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page number 8 and 9, question A and B. We have heard the Mr. Procedural and Senior Standing Counsel appearing for the appellant. And Mr. Apradosh Padmandar, Leonard Senior Advocate appearing for the respondent assessee. The assessee preferred appeal before the learned tribunal challenging the order passed by the Commission of Income Tax within bracket appeals, -10, Kolkata within bracket CITA dated 26/9/2017. One of the grounds urged before the learned tribunal was that the assessing officer who passed the assessment order did not have jurisdiction over the case of the assessee, and therefore the notice as well as the assessment order are bad in law. The learned tribunal took note of the facts and circumstances of the case and found that the assessee filed its return of income, declaring the income to be nil. Subsequently, notice under section 143 within bracket 2 was issued on 10/9/2015 and notice under section 142 within bracket 1 dated 13/6/2016 was issued along with a questionnaire. The assessee contended that the notices were without jurisdiction and relied upon section 120 of the Act. In this regard, the assessee referred to the notification issued by the CBDT in instruction number 1 of 2011. The learned tribunal took into consideration the facts of the case and found that the assessment has been framed by the assessing officer who inherently lacks jurisdiction to do so. Where have they referred to this Bhagyalakshmi?
Paragraph 8.4, I'm sorry. Paragraph 8.4 at page, internal page 6 of the tribunal order.
That page is missing.
But they are appeal.
May
I hand up that copy?
No. You please give that to page 5.
May I just?
Page 6.
মেমো তো বলছে নেই মিসিং
এটা দিয়ে দিই
এটা দিলে এর মধ্যে আসে
আমাদের সার্ভিস আছে দুটো পেজ নেই
The learned tribunal took note of the decision of a coordinate bench of the learned tribunal in the case of Bhagyalakshmi Conclave Private Limited versus DCIT dated 3/2/2021, apart from other decisions, and allowed the assessee's appeal. The revenue had challenged the order passed in the said case in the case of Bhagyalakshmi Conclave Private Limited before this court in ITAT 221 of 2022, etc., and by judgment reported in 2022 within bracket 12 TMI 1514, the appeal filed by the department was dismissed. Wherein one of the questions framed is identical to the substantial question of law suggested by the revenue in the instant case. Thus, we find that the learned tribunal was right in allowing the assessee's appeal and setting aside the order passed by the assessing officer on the ground of lack of inherent jurisdiction. For the above reasons, the appeal is dismissed and the substantial questions of law are answered against the revenue.
Grateful.
Item number 10.
Here there is a 98 days. Miller, the SSC had sold its shares of 39,860 shares of ₹10 at ₹990. So thereby generated a total income of 3 crores 98 lakhs 44,000. Now, my lord, the creditworthiness of the investors and the identity of the investors were not at all proved before the assessing officer. But, my lord, I have lost both before the CIT appeals as well as before the tribunal.
Tribunal followed our court decision.
High Court decision and tribunal followed your lordship's
Abhijit Enterprise.
decision at all.
Abhijit, they have extracted the whole thing.
Yes.
Two decisions have been.
Two decisions.
Two decisions.
Two
of-
decisions.
Two.
Page 32. There is no dispute with regard to the fact the assessee has not received cash or check for the sale of his shares. It has transacted the shares through barter system. This aspect has been considered by the Honorable Jurisdictional High Court recent decision. Deem it appropriate to take note of the same. Then apart from this judgment, there is one more judgment of so-and-so, same line. In the second decision, that is the case of Abhijit Enterprises, the court took note of another decision in VR Global Energy.
Yes.
All right, sir, please come. Delay of 98 days, condone it. This appeal filed by the Revenue Fund of so-and-so, so-and-so. Directed against the order dated May 20th, 2024, passed by the Income Tax Appellate Tribunal B Bench, Kolkata, in ITA 50/KOL/2022 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page 4 and 5, A and B alone. The others are not required. We have elaborately heard so. The Revenue filed the appeal before the learned tribunal, challenging the correctness of the order passed by the Commission of Income Tax Appeals 7, Kolkata, dated 19th February 2020, which was dismissed, affirming the order passed by the First Appellate Authority. After we have elaborately heard the learned Senior Standing Counsel for the Appellant Revenue and the submissions of the learned advocate appealing for the assessee, we find the learned tribunal was fully justified in dismissing the revenue's appeal. We note that the tribunal has referred to two decisions of this court in the case of PCIT 1 Kolkata versus Alishan, ALISHAN Steels Private Limited, ITAT 50 of 2024, dated 19th February 2024, as well as the decision in the case of PCIT 1 Kolkata versus Abhijit Enterprises Limited, ITAT 187 of 2023, dated 17th November 2023. In the second decision, the division bench of this court took into consideration the decision in the case of VR Global Energy Private Limited versus ITO Corporate Ward 3 within bracket 4, 407 ITR 145 within bracket Madras, wherein it was held that when the assessee allotted share to a company in settlement of their existing liability of assessee to the said company, since no cash was involved in the transaction of the said allotment of shares, conversion of this liability in which share capital and share premium could not be treated as unexplained cash credits under section 68 of the Act. The court also took note of the fact that the revenue had filed an appeal before the Honorable Supreme Court against the said decision, which was dismissed in the case of ITO versus VR Global Energy Private Limited, 2020, 113, 113, taxman.com, 31 within bracket AC. Apart from that, two other decisions. One of the division bench of this court in Jaita Investment Company versus CIT, 1994 206 ITR 78 within bracket Calcutta, and the decision of the High Court of Delhi in CIT versus Ritu Anurag Agarwal 2009 7 TMI 1247 within bracket Delhi also support the case of the SSC. The tribunal took note of the above decisions as well as the admitted factual position and dismissed the appeal filed by the revenue, thereby affirming the order passed by the CITA. Thus, we find no question of law, much less substantial question of law arising for consideration in this appeal. Appeal is dismissed.
Item number 11.
No, I'm appearing. There's a delay of 7 days.
In this case,
It's not here.
I have not received wakalatnama and complete papers, my lord. Okay. Lord, after 2 weeks or 1?
Item number 12.
No, there's a delay of 104 days. No, Mr. Mitra is.
My lord.
May it please, Your Lordship. There is a delay of 104 days. I've got my throat problem. I cannot address Your Lordship properly. 104 days delay, my lord.
My only concern is, my lord, there is no substantial question of law errors at all. But because the tribunal has thoroughly examined the entire facts, not only that, before that, the 3 layers, it has been examined, even by our high courts also, my lord.
You are manufacturing rifles, your SSC.
No, it is yes, the main unit is a manufacturing of the rifles. It is an ordnance factory. Now it is a cooperative society of this ordnance factory. It is an employees cooperative society.
My lord, if I could, my lord, indicate the amount of the unexplained casket, it is, my lord, appearing at page 4 of my state petition. That is a 3 crore 77 lakh. That is, my lord, what the assessing officer, my lord, during the course of the assessment have found. And, my lord, several times, my lord, the assessing officer, my lord, had called up an assessee, my lord, to substantiate this amount, because more particular fact of this amount, it was all deposited during the demonetization period. The period in question, my lord, was a demonetization period, wherein, my lord, if Your Lordship kindly turn to page number 9 and 10 of, my lord, the state petition, wherein, my lord, it has been categorically indicated that how many times, my lord, being the assessing officer found this amount to be appearing in the statement of bank account of the assessee, requires explanations from the assessee, and, my lord, have kept on, my lord, calling the assessee for explanations to that effect, my lord. That appears now on page 9 and 10 of the assessing officer, but none of these notices has been replied. No explanation has been offered with regard to the source and
But unfortunately, the assessing officer did not obey the direction of the CIT appeals.
Yes.
He called for a remand report. This fellow said, I will not give. Then the writ petition was filed. Writ petition.
No, actually, writ petition filed again under section 220 subsection 6. What happened? I am telling the facts, my lord. Against the assessment order, I preferred the appeal. They asked for the entire 100% pre-deposit. Against that, I preferred because I preferred application under 220 subsection 6, and our case has been dismissed. They have told no, you have to pay 100%. Then I came before the Calcutta High Court twice, my lord, and twice it has been quashed, and ultimately it is remanded back to the principal CIT to consider my stay application, whether our case is genuine or not. Principal CIT has thoroughly examined the facts. And not only that, before assessment, there is an investigation by investigation wings. And we have explained entire thing. If Your Lordship kindly go through the order of the ITAT, then
now the cash deposit is around 4.8 lakhs.
4.28 lakhs. Only in respect of the SBI account.
Yes, that is,
and
only with regard to only one
officer
account.
triggered the SBI. But Subomoto, we have submitted the other 2 banks accounts also, Axis Bank and the cooperative banks also, bank account also. Everything has been examined by the principal CIT, and after that, principal CIT granted the stay and without any pre-deposit, my lord. And after that, at the same time, the Calcutta High Court asked to complete the appellate proceedings within 6 weeks. So that is why there is no, and not only that, my another important thing is that before the ITAT, the ITAT is given the further chance of whether remand report really asked for or not. I can show the order of the ITAT also, man. And they failed. They have not responded. After that, ITAT, after examining all the things, passed the order, my lord. At page 3, ওটা দিন না। The page 3, my lord, of this. It is the order dated 29 February 2024. And Rule 46 subsection 4 allowed. In the appropriate case, they can consider the.
See, they made a high-pitched assessment of 3.77 crores.
Yes,
Yes,
that
my
is, my lord, that was,
This is why the CIT called for remand report. This fellow sat tight on that.
and my lord,
And
why,
therefore, they examined the accounts and it came to a conclusion that only 4,28,500 was the deposit.
may I be, my lord,
Cooperative
most
society.
respectfully, my lord, indicate, my lord, these facts, my lord, was need to be, my lord, placed before, my lord, the assessing officer, because, my lord, it was, my lord, the assessing officer, my lord, who has acted as an, my lord, investigator as well as an
Oh.
adjudicator.
The tribunal or CIT appeals could have drawn adverse inference. He had no material. That is why that fellow sat tight
No,
without giving a remand report.
And the
before
assessing
CIT,
officer,
we have brought all the documents, my lord.
now, my
all
lord,
the
the
matters.
assessing officer, my lord, has proposed, my lord, this addition by, my lord, issuance of several notices to the assessing.
Correct. They didn't respond.
They didn't respond, my
Then,
lord. Now, my lord, that is, my lord, the assessing officer, my lord,
but
only imposed.
your AO should have kept in mind that they are manufacturing rifles. Please come. There's a delay of 104 days in filing the appeal. The explanation offered by the department is satisfactory and the same is accepted. The delay in filing is condoned. GA 1 of 2025 allowed. Para, appeal filed by the revenue under section 260 Capitally of the Income Tax Act 1961 within bracket the Act is directed against the order dated June 21, 2024 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket tribunal in ITA number 813/KOL/2023 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Page number 4, A and B only. We have heard so also. The revenue was unsuccessful in their attempt in challenging the order passed by the First Appellate Authority dated 11/5/2023 before the learned tribunal, which dismissed the assessee's the revenues appeal by the impugned order. The question which fell for consideration before the First Appellate Authority was whether the high-pitched assessment made by the assessing officer, while a assessment order dated 18th December 2019 in respect of the respondent cooperative society was justified. The First Appellate Authority, while allowing the assessee's appeal by order dated 11/5/2023, has elaborately considered the factual situation and carefully perused the voluminous documents which are placed by the assessee before the CITA. The learned tribunal noted that despite direction issued by the CITA to the assessing officer to file a remand report on the documents and details furnished by the assessee, the assessing officer failed to furnish any remand report. Therefore, the assessee was granted an opportunity by the CITA to place documents before it, which was considered and a decision was taken. Once again, before the tribunal, learned tribunal, the revenue was given an opportunity to rebut the contentions raised by the assessee and to demonstrate as to how the CITA committed an error. We find from the reasoning given by the learned tribunal, the revenue miserably failed to do so. Thus, we are of the view that no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, appeal faces.
My lord, I'm tendering unconditional item number 5 and 6. My lord, I was on my
You
list.
have put your name. Next.
I'm getting.
Item number 13.
Madam, appearing, there's a delay of 41 days, my lord. You know. But I'm led by Mr. Kundali and this madam, Mr. Bipul Kundali. So, Lord, will kindly take it up next minute, next day.
Delay condone.
Great.
Next.
Item number 14.
For the preliminary. Well, there is a delay of 328 days in filing the application for restoration.
It was dismissed for default.
Yes, yes. Madam.
Where, Rashri, where you went? You were not here.
Was under medical.
It's a list, your lordship. I means the list that day, and the client went to another person, your lordship, and he died.
And now he has come back to you.
Yes, yes, come. Yes, yes, because I see all the matters, most of the matters. I'm very angry with.
Affidavit of favor, affidavit of service to the 17.
On merits, what is it? Where is Mr. Udaya Shankar Bhattacharya?
Your lordship admitted the question of law, my lord.
Lordship,
We have paper book, my lord.
two paper books.
No restoration application. What is the issue?
Issue is, my lord.
Your lordship takes up any other day, my lord.
Why?
Yeah, I have missed the brief, my lord.
We'll allow the application and restore. Appeal was admitted, sir. Admitted by the division bench to which I was a party.
Yes.
Real estate agency services or not. And 2017 appeal, suddenly one fine morning you call and dismiss it. Same thing has happened to your department also.
It's happening, my lord.
And already this assessee company is in doldrums.
May I come back day after tomorrow?
No, no, no. We will allow this application. Appeal you come day after tomorrow. How many days delay?
328 days.
That's why, my lord, I want to kindly appreciate him. 320 days delay.
The same argument we will use when you are filing an application for restoration.
But my lord,
So be gracious, sir. We are not asking you to give any concession. Never ever we will record any concession of the assessee. And we heard you as well as the senior advocate on 7th December 2021, and we admitted the appeal. This application has been filed for restoration of the appeal, which was dismissed for default, dismissed for non-prosecution by order dated 3rd May 2024. There is a delay in filing the application. The learned senior standing counsel appearing for the respondent would vehemently oppose the delay in filing the application for restoration and would contend that sufficient cause has not been shown for condoning the delay and the application should be dismissed. We have heard the learned advocate appearing for the assessee on the above submission. The delay, there is a delay of
328 days.
328 days in filing the appeal. The appeal which was dismissed for non-prosecution by order dated 3/5/2024 came to the knowledge of the officials of the assessee company during the month of June 2024. And it took a decision to appoint a learned advocate to take necessary steps so that the matter could be restored and heard on merits. However, the assessee was unable, the officials of the assessee were unable to contact the learned advocate on account of his medical condition. And therefore, they had to engage the services of medical condition, and he did not recover from his illness and passed away during first week of February 2024. It is thereafter the officials of the assessee company contacted the present learned advocate who is on record, and the application has been filed. We do not suspect the reasons given nor doubt the correctness of the reasons assigned for not preferring the application within the period of limitation. One more factor which has persuaded us to exercise discretion in favor of the appellant assessee is that the appeal was admitted on 7th December 2021 after hearing the submission of the learned senior advocate and the learned senior standing counsel for the department. Therefore, we are of the view that when the court was satisfied that substantial questions of law arise for consideration in this appeal, the appeal should be heard and decided on merits. For the above reason, the delay in filing the application is condoned, and the application for restoration application for delay in GA4 of 2025 is allowed, and the application for restoration in GA number 5 of 2025 is allowed, and the appeal stands restored to be heard and decided on merits.
Paper books filed, my lord,
which is filed in court is kept on record. Give paper book.
My lord, kindly record one line, my lord. This application has not been thought upon me as yet.
Yes, that
Yes,
is
sir.
sir.
Give the copy.
Very much, sir. Very much, sir.
Next.
Notice of motion.
Item number 16.
Notice of motion.
Madam, we have served the paper book upon the.
Notice of
represent-
motion is here. Where? Notice of motion. Notice of motion.
You give one more copy, sir. Why are you trying to quarrel with the senior?
I'm not trying to quarrel.
You give your brief.
No.
Take ours and take a photocopy. You should. Always when you make a photocopy, make 2 extra copies. Yes, sir. Where is your appeal before Supreme Court? Your application for extension of time is there.
My lord.
Well, this is not a. Your lordship will see the prayers in their application.
They want
They're asking
stay.
for modification of an
Appeal
order.
dismiss. Where is your
disposed
SLP?
of appeal.
My lord, SLP, my lord, 19th May is the last date for filing SLP before the Supreme Court, my lord. My lord, this order your lordship passed, my lord.
Sir, we cannot modify the order. We have become functus on this, so that direction has become final.
My lord, yes.
We can,
But,
by this application is not maintainable. Where from?
My lord,
I don't know. You show the original side rules or appellate side rules. Where is this application for appropriate orders?
My lord, I have got a judgment of Supreme Court in a case, my lord, where Supreme Court held in 3 judges bench, my lord. There, my lord, Jaipur Vidyut Vitran Nigam Limited, my lord, reported in 2024 Supreme Court online page 313. The judgment is today is not with me. There, Supreme Court held if the order is executory and it is really impossible for
Nothing is impossible for the department. 48 hours you can go to Delhi.
Provisional order, your lordship
Your
confirmed the
lordship kindly seize,
order of release.
kindly seize the order.
We have heard Mr. Udeshakar Bhattacharya, learned senior standing counsel for the applicant in GA2 of 2025, and Mr. Bhatta Ghosh, learned senior advocate appearing for the respondent.
Only, my lord, pay, my lord, kindly keep it up to, my lord, 19th May, my lord.
This application has been filed seeking for appropriate orders. However, on perusal of the prayer sought for by the revenue, we find what they seek for is for modification of the order or for varying the order, modification and / or varying the order dated 19/2/2025 by staying the operation of the order. Such an application for modification is not maintainable, and consequently the application stands dismissed. The department is directed to comply with the direction issued not later than
313.
12th June. List the matter, list the contempt application on 13th June.
That my lord.
Next.
Didi.
But if they don't,
Intra-court appeals item
they
number
file it.
No, no.
We'll know. We'll bring
My,
his.
my lord is here, my lord, then
No, his principal commissioner has not seen the High Court. We'll
The thing is that they think they have seen more than the High Court. That is the problem.
No, no, no.
None of the orders
No,
have
no,
been
my lord.
complied with.
Not
None of the orders.
Not at all, my lord. Department has taken some time, my lord. It is the
mention, you mentioned.
item number 17.
Please, my lords. I'm appearing for the appellant in the matter. But very briefly, before I request your lordships to take, my lord, look into the impugned order, may I indicate the, my lord, facts here? My lord, because in this matter, there are 2 points I will be taking. One is, my lord, while rectification is pending, my lord, no further reassessment proceeding can be proceeded with. That's one of the points. My lord. The other point is, my lord, if there's a reassessment proceeding
Rectification pending before the officer.
before the officer, my lord. And my lord, the other point is, my lord, if a 148 notice has been issued and a return has been filed by us and thereafter there is no order on that return, my lord, then a subsequent 148 proceeding of reassessment is bad in law. These are the 2 short points, my lord. Now, before I proceed any further, the assessment here we are concerned with is, my lord, 2016-17. Your lordship will kindly note the following facts, my lord. Only the dates, my lord. My lord, 17th October 2016, we filed the return. There were notices under 143.2 on 4th of July 2017 and 142.1 on 1st of May 2018.
Either you should have prepared a list of dates and events for the convenience.
May I?
Or what you should do is wait till we note down.
I'm sorry, my lord. I'm so sorry, my lord.
Because I don't know.
I'm so sorry, my lord. I'm so sorry.
143.2 on the what date?
My lord, 4th of July 2017.
Yes. Next.
But I'll not trouble your lordship with another notice, again 142.1. I'm not troubling with that date. We filed a detailed reply. May I indicate that document and the page number?
Date of reply?
That's 16th of November 2018.
See, once you start giving the dates and events,
I'm sorry, I should have.
You complete that and then go.
I'll do that.
16/11/2018. What happened?
We filed a detailed reply with supporting documents. My lord.
Page number?
No, that's page 35.
Then what happened?
My lord, we also filed this online on 27th November 2018 and a show cause notice. A show cause notice is issued on 8th of December 2018. It is at page 71, my lord. There is a follow-up to this notice. That's on 24th of December 2018. It is at page 98, your lordships. And then the order under 143.3 on 30th of December 2018. This is at page 101. This is followed by a demand under 156 at page 110.
What is the date of the demand?
Same date, my lord, 30th December 2018. We prefer an appeal from this before the CIT appeals. That's on 7th of January 2019. It is at page 115, my lord. One of the points which we have taken, my lord, I'm feeling very bad that I should have carried a list of dates. I understand that from next time, my lord, I will.
These are all
I should have. I should have, my lord.
Taught to us means people who have studied in law colleges in India.
My lord, kindly do not embarrass me. My lord, kindly don't do that.
It's all the lighter vein.
I know, my lord. We have a list of dates which is, my lord, but this is not the one which I want.
It doesn't matter. No problem.
That's it.
All right. You filed an appeal.
CIT appeals. That's on 7th of January 2019. In the grounds of appeal, my lord, at page 116, one of the points which we have taken is that no opportunity for cross-examination was given. That's on the merits. The department preferred a rectification and passed an order on the rectification, the department's rectification,
before the
authority,
before the assessing officer.
before the assessing officer. It is at page 118, my lord, on 8th of April 2019. 8th of April 2019, it is an order passed under section 143(3), read with 154, my lord. It is at page 118. Lord, we were aggrieved by this rectification and we filed a rectification on our own. This is on 13th of April 2020.
The assessee filed a rectification.
We filed a rectification, my lord. 13th of April 2020. It is at page 126, my lord. And then, my lord, we made several communications requesting the authorities to dispose of this petition for rectification, which has not been disposed of till date. Those communications start from page 131 onwards. When this was not being disposed of, my lord, we approached the grievance authority. There's a grievance cell, my lord. There we filed a petition stating that this is pending, let this be disposed of. That's on 10th of December 2022. It is at page 137, my lords. While this was pending till now, my lord, now the cause of action starts. My lord, 148 proceeding is initiated. A notice is given on 27th of March 2021.
27th of March 2021.
21. That's before our approaching the grievance authority. It is at page 139. We filed two replies. The first reply is 4th of May 2021 at page 140. We supplemented this with another reply at page 145 of 6th of August 2021. And a further reply on 24th September 2021, which is at page 159. Now, the most important document at this stage is, my lord, after we got the notice, we filed a return. And that return is very important, my lord. That is at page 143.
In pursuance to the 148.
In pursuance to the 148, because that's my point in law. Thereafter, my lord, there was a notice issued under 143(2) on 23rd of November 2021. To which we have gave a reply on 8th of December 2021. Our reply, my lord, is at page 180. The notice is at page 180 and subsequently the reply, my lord. So here, my lord, there is no order passed under 143(3) with 147. So the 148 notice, the proceeding is pending, where the return has been filed. Now we fast forward to the present cause of action. 25th of March 2023, a notice under 148(a)(b) is issued. This starts from page 194.
Along with annexure.
Along with annexure, primarily based on a statement of one individual, Romy Patni. This name, your lordship, will find at page 205 after the first table. No chance of cross-examination of this individual, my lord. We filed a detailed reply on 14th of April 2023. My lord, our reply is at page 212. And the proof of this reply being submitted is at page 206. And what is important of
that
this
is
reply?
acknowledgement.
with the acknowledgement of our, my lord, submission of the reply. And my lord, we have taken this point at page 215, that's the last paragraph of the reply. We have taken the points.
No cross-examination.
No cross-examination, my lord, no. This is 143.3 was issued before, and that there was no failure on the part of the assessor to disclose, my lord, the relevant material or formation of necessary opinion by the assessor.
Therefore,
That's on the merits.
justifying saying that is not a case for reopening.
My lord, in the reply. An order is passed, my lord, 148 AD on 19th of April 2023. This is at page 218.
This was challenged in the writ petition.
This was challenged in the writ petition. Subsequently, a 148 notice on the same day.
Same day.
That's at my lord, page 236. We filed the writ petition. The writ petition is annexed from page 250 onwards. And now,
And what your writ was dismissed?
My writ was dismissed. The order impugned is at page 290.
Saying that you have to file an appeal, is it?
My lord, a bit more than that, it is indicated. If your lordship kindly takes up. In fact, my points were not considered at all. It's at page 290. May I read this portion, my lord? At 290. Has been passed on the basis of 148A(b) of the Act dated 25th of March 2023 on the ground that the assessing officer has sought to reopen the assessment on the very same ground and on the very same issue, which is the subject matter of the pending appeal in respect of the same assessment here. I have perused, so that point was raised by us. I have perused the grounds of appeal in the pending appeal in question on 17 January 2019, which relates to two issues. Firstly, addition of 25 lakhs as unexplained cash credit. Secondly, addition of 1,17,000 as deemed expenditure. When so-and-so appearing for the petitioner was asked to demonstrate from the annexure to the impugned notice under 148A(b) of the Act that the aforesaid issues pending before the appellate authority are also grounds for issuance of notice under 148A(b) of the Act, to which he could not satisfy the court from the reasons annexed to the impugned notice under 148A(b) of the Act. As such, aforesaid ground of challenge is not sustainable in law for interfering with the impugned order under section 148A(d) of the Act. Raises another issue for challenge, challenging the impugned order under 148A(d) of the Act, that the assessing officer has not considered its reply to the notice under 148A(b) of the Act before passing the impugned order, on which perusal of record I find same is not correct. It is not a case that after issuance of notice under 148A(b) of the Act, any procedural irregularity has been committed by the assessing officer, or there is violation of principles of natural justice, or that the impugned order has been passed in contrary to any provision of law, and as such I am not inclined to interfere with the order, accordingly dismissed. My points
after that 143(2),
my lord,
they abandoned the proceedings.
They did not, my lord,
pass an order under 147, read with 143.
So they stayed put, my lord. Now, when they stay put, I'm covered by a few judgments.
No, wait.
My lord, I'm sorry.
First, let us be clear on facts.
My lord.
Please show page 180, the 143(2) notice.
Lordship.
Where volume 1 or 2?
No, that's volume. Just check the volume. Volume 2, my lord.
180. Now you show the 148AB notice, page 194.
No, that's at page 194, my lord.
So the 143 notice was in the different allegation. The allegations are not similar.
Milord,
Are they similar?
no, Milord, this point was not, this is a different point.
It is a different point.
It's a different point. This is
Good for
now,
the SSC, they didn't pass an order under 147, read with 143.3.
Milord, that is my case. Milord, today, if there is all the materials were
If
before
the
the
reasons given
Lordship.
in the notice at page, annexure at page number 182 and 183 onwards is identical to the allegation in the 148 AB order, then it may be different. If it is not so, it is beneficial to the SSC in the sense that they have virtually dropped this allegation without passing an order under 147, read with 143.3.
May I, subject to consideration of your Lordship, may I request your Lordship to take up page 154, Milord? This is the reason for reopening, which was originally given under the 148 proceeding in 2021, Milord.
Now your application for rectification has become infructuous.
But assessment
without
during the
being
pending of the Milord appeal, assessment are also been passed. Milord, Learned Fail also filed Milord one supplementary affidavit.
That's on the, that's while the writ petition was pending, Milord, the appeal was pending. That's a subsequent development.
So your strongest point probably is that no cross-examination.
Milord, also my case is this, Milord, today,
Patmika.
Milord, my case is, Milord, kindly take into consideration, Milord, that there's a 143 proceeding which has culminated in a 143.3.
No. 143.2 notice issued, reply submitted in 2021 February, no order passed.
Lordship, in the 148 proceeding, the first.
Page 212, they are reply to the Milord 148 AB notice. What they have, now my learned friend Milord, now
they have admitted, reply they have given,
acknowledgements. That is the point taken before your Lordship. That point never taken before assessing officer, not in the report.
It's a point of law, Milord. I'm sure my learned friend
for cross-examination.
No,
not for cross-examination. We have taken the point.
154 order, Milord, the application is pending. That is my friend Milord base point to be urged before the Lordship. 154 proceeding is pending, and pendency of the 154 proceedings, Milord, the assessment order also been passed. Now the assessment order also been. Now your Lordship kindly see.
No, that's not really my case. What my learned friend is saying.
Milord, the 148 AB notice page 212. What they have said. But your Lordship kindly see the pairwise details as per your notice date and such has been given. Here, Milord, only Milord page 215.
That's the paragraph I had indicated, Milord.
Please note that the assessment year earlier made on such and such, your previous such and such, there was no failure on the part of assessor to disclose any material necessary for the assessment. Therefore, the assessment proceedings cannot be issued. No point that 154 proceeding is pending.
But
that was there in the writ petition. We had taken that point.
154. What is the bearing on this 148 AB?
I'll indicate, Milord. May I rely on 3 to 4 decisions on the two aspects. First, Milord, it is if there is a 148 proceeding which is initiated, and Milord, a return is filed, and thereafter, Milord, there is no order after the return is uploaded. A subsequent reassessment proceeding on any other parameters, Milord, is not permissible in law. Kindly permit me to rely on, Milord, your Lordship's decision in Coal India Limited. Milord, may I hand over copies? Your paragraph 6 of this judgment you've given the other side. Your paragraph 6. The short issue which arises for consideration in the appeal is whether the assessing officer could have issued a second notice under 148 of the Act when the SSC had filed its return of income in response to the first notice issued under 148A, and such return was not disposed of. The question of law has been answered in several decisions, and one of the earliest decisions is in the case of S. Raman Chettiar, wherein the court held that when a return is furnished by the SSC in consequence of a notice issued under Section 34 of the Act of 22. It was not open to the income tax officer to ignore that return and issue a further notice under Section 34(1)(a) on the assumption that there has been an omission or failure on the part of the SSC to make return of his income. Decision was affirmed by the Honorable Supreme Court in CIT versus Raman Chettiar. There is also a decision of the High Court of Allahabad to the same effect in the case of Commercial Art Press versus CIT. The aforementioned decisions were followed in the case of ASSP versus CIT. Further, a learned single bench of this court has decided an identical issue in the case of Indian Tubes. The underlying principle, legal principle, is that when a notice under Section 148 of the Act is issued, the original assessment proceedings are entirely opened up or left open, and finality, which has occurred in the first assessment order, does not exist any longer. Therefore, without disposing the return of income filed by the SSC in response to the first notice, the assessing officer would not have issued a second notice for reopening of the assessment, which at the relevant point of time did not exist in eye of law.
Was this contention canvassed in your reply at page 212?
This was taken in the writ petition, my lord.
If according to you, this was the best point.
This was something which we had taken in the writ petition, and also, my lord, the point of 154. I'll come to that, my lord. Before that, my lord, may I place Indian Tubes?
These are your lordship, Indian Tubes. Past, appellate proceedings.
It is ready
But
for
not in the read proceedings, because in the read court, what he have urged and what is his submission and what point they have taken, learned single bench take note of that.
My lord, we have also indicated in the grounds of the instant appeal that these points were urged and it was not considered. We have indicated that, my lord. My lord, Indian Tubes, I'm only referring to. There's a third page of the judgment from the second paragraph, my lord. Second, third, fourth paragraph, and I'm placing that the summation of these three paragraphs is applying
Yes,
the
here also they were referred to Raman Chettiar.
Raman Chettiar, and applying these
That's the
principles, the
earliest
same, my lord, that returns are to be considered. Now, thereafter, may I rely on EIT services versus Deputy Commissioner of Income Tax, my lord. Kindly pardon me, it's a judgment rendered by a single bench.
Why
only
do you
for one
multiply?
paragraph.
It's all waste of paper, sir. It's a waste of paper. Raman Chettiar is a settled proposition.
Lordship.
That's it. We will decide based on Raman Chettiar.
Lordship, only paragraph 52 and, my lord, 50 and 52. Internal page 18, it's at the bottom, my lord, that the page numbers is given. Internal page 18, 52, my lord, 50 and 52. Prohibit proceedings under 148, my lord, paragraph 52 is what I'm reading, my lord. When appeal revision reference is pending in the present case, taking note of the details of the table, more particularly noticing the appeal, is hit by the third proviso. This is the part, my lord. Thereafter, my lord, may I rely on Kamdhenu Enterprises, the division bench, my lord, of Delhi High Court. But also on the point of second notice, my lord, paragraph 10 and 11. It actually relies in paragraph 7, my lord, of a decision in Sanjay Garg. And the last page, my lord, after considering GK and drive shafts, my lord, 10 and 11 on the merits of the matter. And on rectification, my lord, the Supreme Court judgment on SM Overseas. Give them a copy. This is on rectification, my lord. The second page, my lord, the last paragraph. Having heard the learned counsel appearing on behalf of the respective parties and having gone through the impugned judgment and order, passed by the court. We are of the opinion that the High Court has committed error in observing and holding that the notice under 154 was invalid, as the same was beyond the period of limitation under 154(7). It is required to be noted that proceedings under 154 were not the subject matter before the High Court, nothing on record. In fact, the notice under 154 was withdrawn on the ground of limitation. The next paragraph, in view of the matter, during pendency, kindly note this part, during pendency of the proceedings under 154 of the Act, it was not permissible on the part of the revenue to initiate proceedings under 147, 148 of the Act, pending the proceedings under 154 of the Act. Here, my lord, it is not in dispute that the proceeding under 154 is pending. Despite our repeated requests, it has not been disposed of, my lord. So this is what I want to place reliance on, my lord. And then, my lord, the classic, my lord, Metro Auto Corporation, which is, my lord, the Bombay High Court decision, my lord, considering Ardor Technopact, paragraph 7 and 10, my lord. So two-page judgment. It is paragraph 7 essentially is the crux, although it's a submission which is affirmed in paragraph 10. I'm carrying Ardor Technopact also, my lord, if your lordship.
Not required.
My lord. It's because it encapsulates this, my lord.
Yes, Mr.
I'm lord, the cross-examination, my lord, I'm not referring, it's your lordship's decisions which we have, my lord, the cross-examination
that
part
we will see.
we have taken, my lord.
Yes.
Now, my lord, there is some factuals. My lord,
No,
here, my
their
lord,
case is 154 is pending, page 127. They have given a reply. I'm sorry, a rectification petition is pending. That is not disposed of. 148 notice issue. They gave 2 reply. You did not pass an order. 148 AB could not have been issued. That's put it in a simple term.
my lord, the read court, my lord, subject to lordship correction, my lord, this is a court of equity. Now, my lord, when your lordship kindly see when the read petition has been filed. Now, my lord, your lordship has seen the, my lord,
page 250.
250, the 148 AD order was passed, my lord,
on
19th April 2023.
250. When was the writ petition affirmed?
Thereafter, the writ petition was filed.
Well, it was 2nd August, my lord, page
2nd
288.
2nd
August 2023.
2nd August, my lord, 2023. Thereafter, my lord, the Honorable Court dismissed the writ petition on 14th August 2023. Now, the present appeal filed, my lord, I believe, October 2024. Just a minute, my lord.
There was a delay, no delay.
But
delay was condoned.
Delay was condoned.
But here, my lord,
there was no delay, I'm told. I'm sorry, there was no delay.
It has been filed. (16th October 2023). Now, the petition was dismissed on August 14, 2023, and the affidavit affirmed in connection with the appeal on 16th November 2023. Now, here in this case, the assessment order also been passed during the pendency of the appeal.
On what date?
They have, that is, my lord, in their supplementary affidavit, my lord, they have annexed the.
You just give the date.
My lord, I'm giving, just giving.
With the date? The 13th of March 2025, my lord, it's at page
13th of March 2025, because my lord, the 31st March is the last date of passing assessment order. Time bar.
All right.
Now, my lord, here, my lord, the department also, my lord, issued one rectification proceedings. My lord, in that rectification proceeding, my lord, assessee did not appear. My lord, you kindly see.
Hundred 118.
Lord, 118. Lord, may I read out, my lord? The instant case assessment order such and such was passed on such and such, whereby total income was assessed such and such. From verification of the assessment order, it was found that addition on account of unexplained cash credit under section 68 of income tax was wrongly adjusted with the business loss. And the tax on the addition under section 68 to be calculated as per provision of under section 115 BBE, which was required to be rectified. Notice under section 154 issued assessee on, there is no response of the assessee. This inadvertent mistake which was apparent from the record thus rectified under section 54 of the Income Tax Act.
Yes.
My lord, our petition may, I'm sorry, I should not be interrupting, my lord. Page 127 is our petition for rectification. The last paragraph is why the rectification was filed by us at page 127.
Yes, my lord, I'm relying page 127 of the Millard, their application. They have said, you are therefore requested to, third paragraph, rectify the order dated such and such by allowing set of laws again addition under section 68 read with section 150 BBE. Their contention is the loss that should be set up with under section addition under section 68. Now, my respect to submission to a lordship, that is not apparent on the face of record. This is not a mistake apparent from the face of record. This may be a ground of appeal, but assessing officer does not have any power to rectify such mistake. But that mistake is not apparating from the assessment order. Whether loss can be set off against the addition under section 64 or not, that is a debatable issue. But Supreme Court also says, I will rely on the judgment. Debatable issue cannot be decided by assessing officer in rectification. Even if today if we say this rectification application is pending, the assessing officer does not have any power to rectify the loss against section 68 addition. And in the first, your lordship may not seen the impugned order. But in the impugned order, the first contention of the petitioner was that the earlier assessment order 143 passed, appeal is pending, the assessing officer reopening the same thing. That is their contention, first contention. The learned single judge, after verifying the records, find that that is not the first, that is not correct. Because the initial 143 that was issued for bogus loan. Here unexplained cash credit. Two separate things. Earlier bogus loan, here 148 AB for unexplained cash credit. Your lordship seen this document, may I not trouble your lordship? Our High Court also, Honorable Justice Kesarvani and Honorable Justice Rajesh Bharadwaj, please to hold that. When the earlier assessment order, if it says nothing about the fresh reopening in any section, it can be reopened, it should be reopened. This is the power having to the assessing officer. Because earlier assessment proceeding, that was not verified. The 148 AB order was issued after search and seizure. Fresh material has been found. Now, may I trouble your lordship?
No, search and seizure on the assessee or a related company?
Not on the assessee, my lord. May I place the one page?
If you see that one page 194.
Yes, my lord. The information has been received in Inside Portal regarding search and seizure under section 122 of the Income Tax Act was carried out at the business and residential premises of Sri Kailash Kumar Patwari.
Who is he?
Kailash
Kumar
Patwari. It is said that Adwell Stock Private Limited is one of the beneficiary of accommodation entry travel by the Kailash Kumar Patwari. Second paragraph. Adwell Stock Broking Private Limited, a beneficiary of such transaction accommodated Sri Kailash Kumar Patwari below mentioned. Now, layer has been particularly given. Thereafter, page 205 is very important.
So this is not relatable to the earlier issue.
No, not at all. Here his
This is fresh
contention is,
material.
here is contention.
Once he finishes, I'll try and answer.
150 only, 154 proceeding is pending. That is his base point. That can be argued before your lordship. But I am subject to lordship correction. Place one judgment. It will say that is not apparent from the order of the assessing officer. It is debatable issue. Whether laws can be adjusted with the addition. Your lordship kindly see
It was not open to the ITO to go into the true scope of the relevant provisions of the Act in the proceedings under 144.
Yes.
154.
That is his contention. Even if I say the 154 proceeding is pending. Whether the assessing officer view that can be adjusted with the 60 addition, that cannot be.
And one thing, Mr. Bag,
my lord,
after you filed the grievance petition,
my lord,
thereafter you did not pursue the matter.
Lord, there are several notices which we have filed. May not kindly take up. And before that, Lord, what submission is being made by my learned friend? May I answer that?
Lord, I have not completed. Now that I am relying on judgment of the Honorable Delhi High Court. Here he says whether and whenever question of taxability of income from a new source of income is concerned which had not been considered by the assessing officer in earlier occasion. The power of the assessing power is there, my lord, in 148 or my lord 263. What is the settled principle of law? Now, my lord, after passing the 148 AB notice, after giving 140 AB notice, 140 AD order, thereafter my lord assessment order. Now, my lord, your lordship, my lord, my respectful submission cannot travel back to the that position. This is a one now today assessment order pass. It is a settled principle law provision of appeal is there. But when your lordship will exercise the discretionary power in under Article 226, well, principle is very simple, my lord. Whether when the violation of principle of natural justice is there, whether there is a patent bar to issue notice, whether any jurisdiction issue assessee submitted before your lordship. In these circumstances, the writ court can interfere with the proceedings. Statute, income tax act itself given step-by-step machinery. Now, one cannot bypass the machinery and come to the writ court in a point when the writ court says the earlier assessment order and now the 148 AB proceeding or not in the same motion, and appeal is also not in the same point, my lord.
Yes, sir.
My lord, what has been submitted by my learned friend is 154 is not maintainable. Lord, had it been,
not saying not
then perhaps I have not understood
No,
it.
what he says is the issue which you have pointed out
Yes, my lord,
is an issue which is debatable or to
so
be
according to him, this is not. It should not be. It should be dismissed. Lord, had
that
that
has not
come,
happened.
I'm very grateful. Had that come from the assessing officer, then I could not have made the submission. My case is it is pending. There is no finding on that 154. Good, bad, indifferent, it is pending. Lord, several communications issued by us We filed this rectification on 13th of April 2020. Our communications started from 13th of April. It's between pages 131 and 136. Your Lordships will kindly take it from page 136 upwards because it's a trail email. So the first your Lordships will find at page 136 is 13th April. Then at page 135 is 30th July. There's a continuous trail of mails, where we have requested and we have kept requesting. From 131 to 136, and then, the grievance is filed at page 137. Kindly see the first line of our grievance petition, at page 137.
Yes.
Please refer to our rectification petition, which is pending since last more than 2 years for refund of this amount. We have earlier filed the grievance on 30th April 2022, which was not resolved till date. On 27th August, the grievance was closed, mentioning the matter is being looked into, but nothing has happened. Details of rectification is mentioned as under. We have given that details, my lord. Please refer to the earlier mails, all the details of the mails given. We are in receipt of the order dated this, raising a demand for additions made under 68 by not allowing the set-off. CBDT has issued a circular number this, dated this, clarifying VD para 4 of the circular that the SSE is allowed to set off other business losses against additions under section 68 read with section 115 BBE of the IT Act till assessment year 2016-17. Thus, order under 143.3 read with 154 passed on 8th of April 2019 is liable to be rectified. Therefore, so we have placed reliance on a circular by which we say it's an error apparent on the face of record. They should have been permitted. There is no adjudication on that. And my lord, on the judgments which have been given, the first judgment referred to by my learned friend is in Bolaram Income Tax Officer versus Volkart Brothers. This is where a 154 was decided upon. That's my basic distinction, my lord. In my case, it is pending, and if it is pending, the assessment is not complete. So whatever fresh proceeding they want to, they can only do it, my lord, once that assessment proceeding has come to a closure. My case is that on two aspects it has not come to a closure. First, 154 pending, and second, 148, when they give us a notice, we upload a return. The moment that return is uploaded, there has to be an order on that. If there's no order on that, then this is still pending. And my lord, the the judgment of Metro Corporation, my lord, Auto Corporation, just give me 1 second. That's on the point that if I prefer an appeal in a proceeding which is pending adjudication, because here my CIT appeals is pending. This is Metro Auto Corporation, my lord. My CIT appeal is pending. So there are 3 points which I am raising, my lord. 154 pending, 148 issued, I have given a notice, the return is given, that proceeding is pending, and the original proceeding through which, my lord, I have preferred an appeal before the CIT appeals, that is also pending. So at this stage, there is no finality of the assessment. They could not have issued a further 148A-B proceeding, which has culminated into this, my lord, the impugned notice under 148 and the order under 148A-B, under 148A-D. The second judgment which my learned friend refers to, my lord, Commissioner versus Sardari Lal, is on a different point altogether, my lord. It's on a power of Commissioner appeals, whether there is a new, because here, my lord, the facts are very different. All this pendency is not decided here, my lord. It was never an issue there, my lord.
Only one thing, my lord, I forgot it, my lord. The judgment passed by the, my lord, Justice Kesavani, I am not giving copy, my lord. When, my lord, the 148 proceedings can be, my lord, drawn.
Yes.
Para 16, 17, 18.
This intra-court appeal by the writ petitioner is directed against the order dated 14th August 2023 in WPO 1478 of 2023. 2023, by which the writ petition was dismissed, giving liberty to raise all the points.
May I take leave, Lord?
Before the assessing officer in the course of the proceedings, subsequent to the order passed under section 148 capital A within bracket D of the Income Tax Act 1961. dated 19th April 2023. During the pendency of the proceedings, the assessment has been completed and an order of assessment the assessment order has been passed on 13/3/2025, which is sought to be brought on record by the appellant assessee by way of a supplementary affidavit. This aspect will be considered in the later part of this judgment. The assessee filed the writ petition challenging the order passed under section 148 capital A within bracket D on the ground that the assessing officer has sought to reopen the assessment in question on the very same ground and on the very same issue, which is the subject matter of the pending appeal in respect of the same assessment year, wherein an appeal was filed before the Commission of Income Tax Appeals on 7 January 2019, challenging the assessment order dated 30th December 2018, passed under section 143 within bracket 3 of the Act. The learned single bench perused the grounds of appeal which had been filed before the CIT within bracket A and found that the reasons that the prime facie reasons set out in the notice issued under section 148 capital A within bracket B dated 25th March 2023 is different, and therefore the contention raised by the assessee was not accepted. Apart from that, the learned single bench was of the view that there is no procedural irregularity committed by the assessing officer while issuing the notice under section 148 within bracket B of the Act, and therefore the writ court was not entitled to interfere with the order dated 19th April 2023. Before us, Mr. Bagh, learned advocate appearing for the appellant, has raised certain other issues which appear to have not been canvassed in the writ petition in the same form as placed before us. Nonetheless, since we have elaborately heard the learned advocate for the appellant on the said submissions as well as the learned senior standing counsel, we proceed to discuss the same and take a decision on those points which have been urged. The first contention is that as against the order of assessment passed under section, please take your seat. Passed under section 143 within bracket 3 dated 30th December 2018, the assessee filed statutory appeal before the CIT within bracket A on 7/1/2019, and several grounds were urged and the appeal is pending. During the pendency of the matter, the department filed a rectification application under section 154 of the Act, and an order was passed on 8/4/2019. Subsequent thereto, the assessee has filed an application under section 154 of the Act for rectification on 13/4/2020, which is still pending and not disposed of. Several communications were written, several emails were sent to the assessing officer to decide such a rectification application filed by the assessee. However, they were not favored with any reply, and therefore the assessee filed a grievance petition before the grievance redressal authority, and though it was stated that the matter is being looked into, nothing happened thereafter, and therefore the notice issued under section 148 capital A within bracket small b of the Act could not have been issued by the assessing officer. The second contention is that a notice under section 148 was issued on 27/3/2021, for which the assessee submitted 3 replies on 4/5/2021, 6/8/2021, and 24/9/2021, and also filed a return pursuant to the said notice. And no decision was taken on the return, and subsequently a notice under section 143 within bracket 2 of the Act was issued on 23/11/2021, for which a reply was submitted On 8/12/2021 by the assessee. However, no orders were passed. Therefore, the subsequent notice could not have been assessed. Therefore, a notice under 148 capital A within bracket small b of the Act could not have been issued. Thus, it is submitted that apart from that, other issues were raised in the reply submitted by the petitioner to the notice issued under section 148 capital A within bracket small b of the Act, which were not considered in the proper manner, and an order has and therefore the order passed under section 148 capital A within bracket small d of the Act dated 19/4/2023 is vitiated. In support of his contention, the learned advocate referred to the decision in the case of Principal Commissioner of Income Tax versus Coal India Limited, 2023-146 taxman.com 546 within bracket Calcutta, and also the decision of this in the case of Indian Tubes, also as a decision of this learned single bench of this court in Indian Tubes Company Limited versus Income Tax Officer, 2005-272 ITR 439 within bracket Calcutta, and the single bench decision of the High Court of Karnataka in EIT Services India Private Limited versus DCIT, 2024-159 taxman.com 424 within bracket Karnataka. Reliance was also, for the other proposition, Reliance was placed on the decision of the High Court of Bombay in Metro Auto Corporation versus Income Tax Officer, 2006-286 ITR 618, and the decision of the High Court of Delhi in Kamadhenu Enterprises Limited versus ITO, 2023-146 taxman.com 417 Delhi. We have reference was also made to the decision of the Honorable Supreme Court in the case of SM Overseas Private Limited versus CIT, Civil Appeal numbers 3612-3613 of 2012, dated December 7, 2022, for the proposition that during the pendency of the proceedings under section 154 of the Act, it was not permissible on the part of the revenue to initiate proceedings under section 147/148 of the Act. We have elaborately heard the submissions of the learned, Senior Standing Counsel on the above submission. The learned Senior Standing Counsel has relied upon the decision in the case of T.S. Balram versus Wolcott Brothers, 1971-82 ITR 50 within bracket SC, semicolon. CIT versus Sardari Lal and Company, 2002-120 taxman 595 within bracket Delhi, and the decision of the division bench of this court in ITA number 71 of 2018, dated 21st May 2024, to explain the circumstances under which the power under section 148 capital A within bracket D of the Act could be invoked. We have elaborately heard the learned advocates for the parties and carefully perused the materials placed on record. Before we go into the judgments, we need to be clear on facts. The assessment was completed and an order under 143(3) was passed on 30th December 2018, and a consequential demand was also issued under section 156 of the Act, against which a statutory appeal is pending before the CIT within bracket A. The department filed a rectification application and opportunity was granted to the assessee to appear before the authority who sought to rectify the assessment, as it was found that the addition on account of unexplained cash credit under Section 68 of the Act was wrongly adjusted with the business loss, and the tax on addition under Section 68 is to be calculated as per the provisions of Section 115 capital B, capital B, capital E, which is required to be rectified. Despite opportunity, the assessee did not respond, and the assessing officer came to the conclusion that it is an inadvertent mistake which is apparent from the record, and accordingly passed the order under section order dated 8/4/2019 under section 154 of the Act. Thereafter, it appears that the assessee filed an application for rectification on 13/4/2020, requesting the assessing officer to rectify the rectification order dated 8/4/19 by allowing set-off of loss against addition under section 68, read with section 115 capital B, capital B, capital E of the Act. As rightly pointed out by the learned Senior Standing Counsel for the Revenue, the prayer sought for in the application filed by the assessee for rectification of the rectification order dated 8/4/2019 is a contention which is raised on the merits of the matter, and it is doubtful as to whether at all such prayer is maintainable under section 154 of the Act. However, we find that certain other facts which have come to our notice would make this issue academic in the case on hand. We say so because the notice issued under section 148 of the Act dated 27/3/2021 was on certain grounds, and the assessee sought for reasons by representation dated 4/5/2021, filed their return of income, and subsequently also filed their reply dated 6/8/2021. Copy of the said reply is annexed at page 146 of the state petition, and on a reading of the same, we find that the reply is by referring to certain legal issues and decisions and circular of the CBDT, and nothing appears to have been stated on merits. Nonetheless, no order under section 147 of the Act was passed as proposed in the notice dated 27/3/2021. The question would be whether the notice under section 148 capital A within bracket B of the Act dated 25/3/2023, which was challenged by the assessee after the order was passed under section 148 capital A within bracket D dated 19/4/2023, was maintainable on the aforementioned grounds raised by the learned advocate for the appellant. To get an answer, we have perused the notice issued under section 148 capital A within bracket B dated 25/3/2023, and we find that the information was received by the department in the Insight portal regarding search and seizure action under section 132 of the Act carried out in the business and residential premises of one Kailash Kumar Patwari and his key persons and entities controlled and managed by Kailash Kumar Patwari on 8/3/2022. The reasons as set out in the said notice dated 25/3/2023, is by alleging that the assessee is a beneficiary of transactions accommodated by Kailash Kumar Patwari. Thus, we find the reasons which have been set out for initiating the proceedings are 148 capital A within bracket B are completely different and has no bearing upon any of the proceedings which are pending or disposed of. Therefore, the department were well within their jurisdiction to issue the notice under 148 capital A within bracket B, and thereafter to proceed the order passed, proceed to pass an order under 148 capital A within bracket small d. So far as the decisions which have been referred to by the learned advocate appearing for the appellant assessee, it would suffice to note the decision in the case of, suffice to note the earliest of the decisions of the Honorable Supreme Court in the case of CIT versus Raman Chettiar, 1965-55 ITR 630, which decision has been followed in the case of Indian Tubes Company Limited and also noted in EIT Services India Private Limited. In the said case, the issue was the decision was to the effect that when a notice under section 148 of the Act is issued, the original assessment proceedings are entirely opened up or left open, and the finality which had occurred in the first assessment order does not exist any longer. Therefore, it was held that without disposing of the return of income filed by the assessee in response to the first notice, the assessing officer could not have issued a second notice for reopening of the assessment, which, at the relevant point of time, did not exist in the eye of law. To the same effect is the decision of the Honorable Supreme Court in SM Overseas Private Limited. In our considered view, these decisions can be of no assistance to the case of the assessee, as on facts we find that the proceedings under 148 capital A within bracket small b of the Act was initiated pursuant to a search and seizure operation which was conducted against the above named person and his entities, and the allegation is that the assessee was a beneficiary. Therefore, we are of the view that the reopening proceedings would not suffer from any jurisdictional error, nor there has been any jurisdictional error for the writ court to interfere in exercise of its powers under Article 226 of the Constitution of India. At this juncture, it would be relevant to take note of the decision in Sardari Lal and Company, wherein the Honorable Division Bench held that whether the question of taxability of income from a new source of income is concerned, which had not been considered by the assessing officer, the jurisdiction to deal with the same in an appropriate cases may be dealt with under section 147/148 and section 263 of the Act if requisite conditions are fulfilled. Thus, for the above reasons, we find no grounds to interfere with the impugned order. With regard to the assessment order which is sought to be brought on record by the assessee by way of a supplementary affidavit dated 20th March 2025, we are unable to entertain any challenge to the assessment order for the reasons which I have set out in the preceding paragraphs, and it will be well open to the assessee to work out his rights and remedies available under the provisions of the dismissed.
I'm very deeply obliged, my lord. But may I only pray for an indulgence because, my lord, we will be out of time for filing the appeal now. My lord, from this order, it's 13th of March. We are, my lord, in May. We'll have a very short time, my lord. May I only have this?
How much time you will require?
Lord, 4 weeks, my lord, to file the appeal.
After the above judgment was dictated, the learned advocate appearing for the appellant submitted that the appellant is desirous of preferring a statutory appeal as against the assessment order, and if an appeal is filed as of now, the same would be barred by time. Considering the fact, considering the fact that the matter was heard and decided today, we do not wish to foreclose the rights and remedies available to the assessee, and therefore we grant 30 days time from the date of receipt of the server copy of this order, judgment and order, for the assessee to prefer an appeal before the first appellate authority. If such appeal is preferred within the time permitted, the appeal shall not be rejected on the ground of limitation.
I'm very deeply obliged, my lord.
Deeply obliged.
Before you rise, your lordship rising, I mentioned next two appeals, 18 and 19. Parsi particularly is appearing in this matter, my lord. He came on 2nd of May, but court did not in session. But it will taken about 20th of June in the earlier two matters. Let it be written in his position as it is, my lord. Let the order be passed on this aspect, my lord. If it will take down.
At the request of the learned advocate,
Same position, my lord.
On 20th June.
20th June. Deeply obliged.
So, Roy, should we
Yes.
My lord, with your lordship's permission, Honorable Justice Chatterjee, my lord, I'm mentioning that matter. My lord.
Contempt.
Contempt till now has done. I'm grateful.
Lordship, may I seek leave to file appeal without certified copy?
Date of order.
Lordship, it is July, but the problem is the matter is running in the list and the file is in the court. So unless the matter gets released, they cannot. I have applied for the certified copy, but it is not being obtained because it is running in the monthly list.
We'll ask them to issue certificate copy. No problem.
Lordship.
Our AC will talk to them and they.
Lordship.
We will issue certificate copy by tomorrow.
Lordship. Grateful.
Lordship, leave to file appeal without
Date of order.
16th April, Your Lordship.
Leave your honor.
My lord, may I permit to mention one matter, Lordship? Lordship, this is the appeal matter, Lordship. I know Lordship has no determination, but Lordship, your Lordship was pleased to pass an order September 18, 2023, Lordship, and direction was given before the district magistrate to take immediate action to
Mention before the bench having determination.
my lord, this is the
Because we have
appeal
got a
matter,
very
Lordship.
big list in this determination also.
Lordship, kindly give some time, Lordship, kindly, Lordship. Lordship, this matter, Lordship, the honorable single bench
You mentioned tomorrow before the bench having determination.
My lord. My last, may permit to mention, my lord, the matter relates to upgradation of pay scale for TPSC law officers. The matter was heard and affidavits were exchanged. The matter was returnable after 3 weeks but did not listed, therefore.
Let us, you give the numbers, we'll try to include. First, we have to progress on whatever has been listed.
I'm praying for.
You give the letter, let us see.
For inclusion,
Grateful, my lord.
6 appeals, my lord. In one matters, I am claiming CS benefit, in another matters, I am claiming leave encashment. The petitioner is more than 80 years old.
I'm praying for inclusion of 2 matters, my lord, under section 30 of the Workmen Compensation Act, Employees Compensation Act, my lord. My lord, we have deposited the amount with the authorities, my lord. The difficulty is, my lord, the commissioner is proceeding with the matter. Matter was fixed today before the commissioner, my lord. He is unwilling to pass any, not to grant any more time because the workman there, my lord, is praying for release of the dues in her favor. The original workman has died. They are.
Now you're for the management.
I'm for the management, my lord.
So pre-deposit is as per the statute. The entire amount has to be deposited before the controlling authority.
But I have done that, my lord.
No, not controlling authority.
Before the commissioner.
Commissioner.
Yes, my lord. And
what is he trying to do?
My lord, the other side, the employee, my lord, is taking out applications, praying for release of the amount since there is no stay.
Obviously.
And my lord, the commissioner is not really in favor of granting much time. He has not fixed a date today.
So as against the order passed by the commissioner, you are on appeal.
My lord.
That has to be heard by a division bench.
My lord. Well, we have removed the defects, my lord, as per the Registrar General.
It's a fresh matter.
It's a fresh matter.
Oh, please give. Please call.
Appellate site, monthly list, serial number 1.
Led by Mr. Raichandani in this matter, man.
I appear for the status.
Your Lordship, I am appearing for the petitioner, Your Lordship.
Sir, your video is not there, sir. Your audio is clear. Yes.
Your Lordship, I think there is some technical glitch.
Can you log out and log in once more? In meantime, Chatterjee, you tell us the facts.
My lord. There was a direction for filing the second judge's copy, my lord. We have complied with that. My lord.
You filed it?
My lord. I have filed it, my lord. It has been renumbered now, my lord.
Now, what was the order which was put to challenge?
Kindly comes to page 36, my lord. This is the
36.
That's assessment order.
Assessment order.
That is assessment
and the
tribunal's order, my lord, is at page 74.
First issue is covered by decision.
My lords.
So far as the concern, so on, so on, so. Now, appellate authority has been directed to dispose of the appeal.
My lord.
They did not
My lord, they did not prefer the appeal, my lord. They did not proceed. Thereafter, they prayed for extension of time, which is at page 78.
Now, is the appeal, why have you not
Well,
filed it?
this point is of jurisdiction. That is the main point in the appeal, my lord.
No. Show us the grounds raised before the tribunal.
For the tribunal. Oh.
Page 133 onwards. Entirely based on pre-deposit.
You wanted the tribunal to decide this issue.
My lord.
No. The two grounds were raised. One is on the merits of the matter. The second is section 84. 84 has been upheld.
Decided by your lordship.
So your why can't the appellate so you want to avoid the pre-deposit?
That is the main.
How much is 15%?
Well, the total amount is 16 crores and odd.
All right, pass over. You speak to Mr. Rai Chandani. His audio is pass over.
But he's there, man. But he's
May
there.
please, Lordships. My apologies, my lords. My apologies.
yes,
Lordships. You're able to hear me, my lords? Lordships. My lords, this is a matter where they have done best judgment assessment, my lords. My turnover is 100. They have added 40% to my turnover, my lords. I have no difficulty, my lords, that they say that you are liable to pay tax on entire 100. My lords, I am a works contractor. I undertake works. They are entitled to collect VAT on the value of the portion of the work. The VAT. Because what has happened, I am a registered assessee, I am filing my returns, but the officer has done best judgment. Because they cannot do best judgment against an assessee who is registered, who is filing returns, paying taxes. Best judgment can be done against an unregistered assessee.
It's not a best judgment.
Exactly. Or if or if the books of accounts are rejected,
Lordships.
Then the AO can do a best judgment assessment.
Lordships. What they have done is, my lords, he has added saying that I will add 40% to your entire turnover. My balance sheet is 100. They have added 40%. Plainly, my lords, arbitrary. My only request was before the tribunal that let them only examine this point, my lords.
No, please show us the grounds of appeal before the appellate authority. Not before the tribunal.
No, my lords, in this case, I'll just tell you, lords, what had happened. We had challenged this order before the tribunal because the tribunal under the West Bengal tribunal, my lords, has power of deciding the constitutional validity also. That was also challenged, my lords. That has been negated by your lordships, my lord, and therefore the tribunal says that issue is already concluded by your lordships, my lord. Lordships.
It's not a case of best judgment.
So let us see the assessment order.
Lordships may kindly have
Page 37.
Page 37.
And this was finally heard. They were served with a copy of the draft assessment order. They replied to the draft assessment order. The draft assessment order is at page.
Then, how can it be a best judgment?
It's not a best judgment. My learned friend says, my lordship kindly sees. Draft assessment order is at page 92.
92, yes.
11 June 2018.
Yes.
Then objection to the draft assessment order is at page 114.
But does he use the word expression best
No,
judgment?
I subject to correction, I do not find that. In fact, at page 37, my lord, the assessment order, I'm sorry, my lord, the reply is at page 114. And at the assessment order at page 37, my lord, sixth line from the top, the case was finally heard on 19 June 2018 when the dealer made a written submission along with annexure and some books of accounts and documents in reply to the draft order. But the whole case is with regard to the challenge to the second proviso to section 84. The entire grounds. Or that chapter is closed because of your lordship's judgment. না কোথায়
Excuse me, kindly have page 55. Internal page, my lords, running page 42 of the assessment order, my lords. I'll just show one line, my lords. I'll correct my learned friend, my lords. I'll just show one line.
Best of my judgment.
Is determined to the best of my judgment as follows. As per report, turnover is this. Add this less total, adding 40%.
This is with regard to non.
Adding 40%.
On what basis this 40% was added?
My lords, I do not know from where they've added this 40%, saying that I will add it to your entire turnover. My lords, my income is 100. You're demanding tax on 140. On what basis, my lords? That's my submission. Lordship, may kindly see one more line. In light of the above discussion, I am constrained to reject the report and proceed to estimate the same to the best of my judgment.
No, it can't be best of your judgment.
Lordship, that's
based upon the profits or book profits recorded for the previous years.
So CTP to that na boye. CTP to that boye.
Contractual transfer price. Very good.
Contractual transfer as per VAT.
He did not produce the document.
But he did not produce the documents.
That is the part of it.
But then, sir, please come to page 38.
Lordships.
The entire page is in italics.
Lordships.
Paragraph 3.
Lordships.
From the case records assessment pertaining previous periods, it is found that during the process of hearing of assessment, those periods, dealer furnished profit and loss account for the operations in West Bengal, wherefrom it came to light that the dealer did not include in its computation the contractual transfer price, the revenue recognized from the execution of the works contract in full. This year he has failed to furnish the same. Then he says section 2, 110, etc., etc.
Lordship, my submission before the authority was. Lordship, may I just point out, my books are, I am an assessee, which is one. I'm one company filing one balance sheet, one profit and loss account. They want an individual profit and loss account for only West Bengal. I can produce that, my lords. I can produce that. But that, my lords, my submission cannot be a ground to say that I will go beyond 100. I will assume that your turnover, lords, they can reject it and demand tax on 100. This best judgment, where does it come from, my lords? Why can't they add 40 or 80 or 100? They can add anything, my lords. If they reject my books, my lords, they can demand tax on the turnover only, not beyond it, my lords. Therefore, my only limited prayer today before your lordship is let them...
What they can do is, if they come out to the case of underreporting.
Yes, lordship, I am obliged. If they say so, my lords, I have no difficulty. That your turnover is actually 140, but you have reported only 100. Therefore, I'm adding it. That is not the case. He's saying best judgment, I add 40%.
He should give some reasons why he has added 40%.
If your lordship kindly sees first line of page 39. First of all, my lord, page 42, which he was showing, the bold italics part, my lord, but your lordship may kindly keep it in mind, my lord. This is, my lord, bypassing the efficacious alternative remedy. He is taking your lordships to the merit of the case because he wants to avoid the pre-deposit.
They are trying to make the order passed by the tribunal, upholding that, closing that point as unworkable.
Unworkable, and he is trying to, my lord, he's assailing the assessing authorities order before your lordship. Now, if your lordship kindly sees page 42, the very first line, I therefore see no reason to debate from my following observation due and finally assess CTV. I am compelled to constitute this non-production as a purposeful non-furnishing of material information leading to possible under-assessment. He did not. If your lordship kindly sees page 39, the first line. If this revenue was not included in the CTP in assessment order, the latter would have lost credibility as a measure of value of the contract.
But then, sir, Mr. Siddiqui, please come to page 39.
39.
Regarding non-production of P&L for West Bengal, the dealer's explanation is in the last paragraph. He says, as per the West Bengal Act, so and so, so and so, so and so. This reason is there. Against said contractual receipts, company has incurred expense of material, labor, etc.
CTP. Against said contractual receipts, company has incurred expenses on material, labor, and services, which include consumption of building material as well as labor and services. In addition to execution cost expenses, also includes costs attributed to claims raised by the company pending with clients or under arbitration and reported in books, along with WIP. These claims also relates to contracts under execution that encountered delay due to reasons not attributed to company, hence not included in closing WIP taken in the computation.
But this rejoinder,
No,
but this lordship kindly sees that after the italics, but this rejoinder can in no way account for non-submission of profit and loss account for the operations in West Bengal. It appears from the assessment records of the previous year that the dealer followed the practice of preparing state-wise PL accounts before consolidation into All India report. The PL account prepared for West Bengal certified by the auditor was submitted at the time of assessment for last many years. This year, the dealer has deviated from the practice without any explanation. Furthermore, the dealer has provided no certificate from the auditor on operations in West Bengal containing his comments on significant account policies. Instead, the dealer has produced an unaudited trial balance. It may therefore be construed the auditor who certified the balance sheet for All India operation does not certify the results of the operation in West Bengal that the dealer intends to report. It cannot therefore be said that turnover and CTP reported in the returns or in Form 88 report the actual amount taken in the said actual report. So this is my explanation.
The dealer, while filing the appeal, I mean,
objection.
What is it called? Revision petition. Application under 8. Page 134, ground 2. This is his explanation. He has maintained VAT audit report for each of the state, and therefore this finding is erroneous, he says.
That
page 134, ground 2.
Ground 2, my lord, I've seen. But your lordship, again, my lord, may I reiterate, my lord, for you? But for the state of West Bengal,
2018 assessment.
He has done nothing. But he was supposed to file an appeal, your lordship knows.
You didn't.
But he is avoiding.
You could have issued a bank attachment notice.
But that instructions I do not have. Whether any
by then now GST has come.
Bank attachment, no. Still, my lord, we can, my lord.
Transitional credit you would have availed, swiped off his present ledger.
Because he was there before the learned tribunal. Thereafter the tribunal
granted. We'll send it back to the AO to consider this. 40% is unreasonable.
But your lordship kindly appreciates, my lord, after so many years, and everyone will be bypassing this, my lord, the alternative remedy will come up before your lordship.
That is correct.
Your lordship may kindly.
We'll see.
And the learned lawyer submitted before the tribunal that I am seeking liberty to prefer.
This now the lawyer has changed. This our writ petition has been filed challenging the order passed by the West Bengal Taxation Tribunal. Where is that now? Useless filing system. Okay, 74. Challenging the order passed by the West Bengal Taxation Tribunal dated 3rd October 2024 in RN number 960 of 2018. The said application was filed under Section 8 of the West Bengal Taxation Tribunal Act. What is the act from? Of the Section 8 of the West Bengal Taxation Tribunal Act 1987. Challenging an assessment order dated 27/6/2018 for the period 2015-16 under the provisions of the West Bengal Value Added Tax Act 2003, here and after referred to as the Act. Primarily, two grounds were raised. before two sets of grounds were raised. One with regard to the constitutional validity of the amendment made to section 84 of the Act, read with rule 138 within bracket 2 within bracket small b within bracket IA single bracket of the VAT rules 2005 as being unconstitutional, unreasonable, or arbitrary. The second set of grounds was on the merits of the matter, questioning the addition of 40% to the contractual transfer price within bracket CTP and making an assessment on the same and levying tax. On the first aspect, the learned tribunal was right in holding that the validity of the amended section 84 has been upheld by the division bench of this court, and therefore the petitioner cannot canvass such a ground. With regard to the other issue, the learned tribunal held that the writ petitioner has to avail the statutory appellate remedy, and it appears that the learned advocate appearing for the writ petitioner had agreed to exhaust such remedy. The petitioner has challenged the order passed by the learned tribunal Where is the writ petition? Mr. Chatterjee, where is the writ petition? Mr. Victor Chatterjee, yes. Yes. Tribunal. On the ground that there is absolutely no basis for adding 40% of the total contractual transfer price declared by the petitioner, and such addition was wholly unjust and improper without taking note of the specific submission made by the assessee during the course of assessment proceedings as well as before the tribunal. In other words, the learned tribunal, the petitioner, while accepting the fact that the amended section 84 has been upheld, sought to canvass the grounds, the other grounds, which touch upon the merits of the assessment. However, what could be seen from the order passed by the learned tribunal is that the learned advocate who had then appeared for the petitioner had agreed to move the appellate authority, and this has been recorded so in the impugned order passed by the tribunal. Have you said anything on that? Where is he, sir? So, Mr. Raichandani, what have you said about the concession given by
Lordships? My lords, we have said so that it's a concession, my lords. Even a concession is made in law, my lords, not binding, my lords. My lords, may just give me 1 second. I have said so. In the lordships are aware, my lords. Lordships are aware a concession not made in law, my lords.
However, it appears that the petitioner has not given any written concession seeking to go before the appellate authority, and it appears to be a submission made by the then learned counsel who appeared for the petitioner, which has been recorded by the tribunal. Even assuming a concession is given, unless the same is unequivocal, the same will not bind the party. Be that as it may, we find that the assessment order dated 27/6/2018 is undoubtedly a high-pitched assessment. In more than one place, the assessing officer uses the expression best of judgment, inverted comma. This obviously could not have been a best of judgment assessment, since a draft assessment order dated 11/6/2018 was drawn. The petitioner was granted opportunity to place his submissions, which were placed, and the submissions have been recorded in the assessment order dated 27/6/2018. And if that be so, the assessing officer is required to reject the submission and then take a decision on the merits based on the profit and loss account and other documents and credentials, and the assessment could not have been on best of judgment basis. Having steered clear of this issue, with regard to issue, we find in the assessment order, after setting out the stand taken by the writ petitioner in their written submissions dated 19/6/2018, the assessing officer has pointed out that the petitioner/dealer has deviated from the practice which they had followed in the earlier years without any explanation. If the dealer is entitled to a dealer is undoubtedly entitled to resort to tax planning, but not tax avoidance. Therefore, avoidance. That apart, each assessment year is an individual unit, and there can be no fetters or bar put on an assessee/dealer to resort to any provisions of the Act, so that the amount of tax payable on a particular transaction is assessed appropriately. The assessing officer also states that the dealer has not provided certificate from auditor on operations in West Bengal. However, before the tribunal as well as before this court, the writ petitioner has raised the following grounds. Sir, the above aspect of the matter has to be gone into, since it is a specific case of the petitioner/dealer, that in respect of the works executed in West Bengal, separate VAT audit report is maintained by the petitioner, and the said report is duly certified by the chartered accountant of the petitioner, and that VAT audit report was duly produced along with consolidated profit and loss account before the authority at the time of assessment, but the assessing officer insisted for separate profit and loss account in respect of West Bengal. Full stop. It is a further submission that VAT audit report prepared for West Bengal would give the total picture of the works executed in West Bengal. And the mere fact that profit and loss account was not produced for the state of West Bengal, adding 40% to the contractual transfer price within bracket CTP, was unjustified. Other factual explanation has also been given by the petitioner/dealer. As pointed out above, if this be the factual position and the contentions advanced by the petitioner/dealer, the same are required to be gone into by the assessing officer, and the assessment should be completed on merits and not on best of judgment basis. One more aspect which is conspicuously missing in the assessment order is to the basis of the addition of 40%. No explanation is forthcoming, as could be seen from the assessment order. Therefore, we are of the view that the matter should be re-examined by the assessing officer after affording an opportunity to the petitioner to produce documents and particulars, and after affording an opportunity of personal hearing to the authorized representative, either virtually or in person, the fresh assessment order be passed on merits and in accordance with law. Under normal circumstances, we would have set aside the assessment order in its entirety. But however, considering the fact that the assessing officer has made certain observations in the assessment order dated 27/6/2018, on which the petitioner/dealer had no opportunity to put forth the case, those observations shall be treated as a show cause notice. And the petitioner is directed to submit their reply along with supportive documents within 3 weeks from the date of receipt of the server copy of this order, after which an opportunity of personal hearing shall be afforded to the authorized representative of the petitioner/dealer, either virtually or in person, and fresh assessment order be passed on merits and in accordance with. Yes.
We are obliged.
Your Lordship may kindly, my lord, record, my lord, on the unusual facts and circumstances, your Lordship is, in spite of there being an alternative.
It is made clear that this order has been passed considering the peculiar facts and circumstances of the case and not to be treated as a plea.
Because this is the second case within a month, my lord. They are bypassing this alternative remedy.
Next.
Serial number 2.
We are obliged, my lords. Obliged.
I appear for the appellant.
I appear for the respondents.
Freedom fighter pension.
No, my lord. This is
Constable.
with regard to, my lord, dismissal
Seeing
from
madam, we
service.
thought freedom fighter. What is the issue?
My lord, this arises out of, my lord, an order for dismissal from service. My lord, under the...
He was working in which department?
CRPF.
My lord, under the CRPF, my lord.
CRPF, Central
My lord,
Reserve
this, my
Police
lord,
Force.
an order, my lord, was passed for dismissal from service. My lord, on the grounds that, my lord, that he was my lord, he had deserted his force, my lord, his post, my lord. My lord, if, my lord, there is one...
What was the period during which he was,
my lord,
he left service?
10 days, my lord.
10 days.
Yes, my lord.
But Supreme Court says disciplined force, paramilitary forces, scope of interference is very less.
My lord,
let us see the charge memo dated.
My lord, if my lord comes to page 52.
21st March 2009.
My lord,
Page
53.
54.
Yes, my lord.
Correct?
Yes, my lord. It starts from 52, my lord.
Articles are here. Page.
Yes, my lord.
Without any information, is a deserter.
My lord, this is, my lord, the...
Did you argue on proportionality?
My lord, yes, my lord. There was, my lord, at the time of, my lord, the departmental inquiry, my lord, the accused, my lord, had pled guilty. My lord, pled guilty, my lord. He had pleaded guilty.
Pleaded guilty.
My lord, however, my lord, there is one small submission that is to be made, my lord, is, my lord, with regard to the difference, my lord, in desertion and, my lord, absenting from...
No, once you have pleaded guilty, you should have argued only on proportionality.
My lord,
saying
that
that
has...
past record of service was good. I never deserted
my lord, that
service.
has also, my lord, been done, my lord. My lord, he was, at the time of, my lord, the appeal itself, my lord, only 42 years old. My lord, and there were no other disciplinary, my lord, charges created against him, my lord, before this. My lord, this was the...
And did you argue this point before the single bench? No. Proportionality you didn't argue.
My lord, it seems not.
Why? That should have been your first point. At least in this appeal, have you raised this ground?
Yes, my lord.
Please show.
Lord, at paragraph 7, my lord, has been mentioned it, my lord.
Why don't you consider, madam, if some
Paragraph.
lesser penalty?
Lordship will kindly see what had happened, Lordship. It's very difficult, Lordship. He deserts the camp.
In
without
Kashmir.
in Kashmir. 2008 in Kashmir, he deserts the camp.
You use the mic.
An FIR had to be lodged because he could not be found. And on the very date, on that date, an FIR is lodged against him on charges under Section 307 IPC. So this was this was a small sequence of the offences, Lordship. The situation, he had gone to an hotel where another member of the force was there. There was a, I mean, he was accused under Section 317 for attempting to murder that member of the force. So this was the situation. I mean, therefore, Lordship, it was it's very difficult to review the situation considering the charge, Lordship.
But the article of charge doesn't refer to the criminal case.
Lordship, article of charge. Lordship, yes, Lordship.
Oh, this fellow damaged the
Yes, concertina wire.
concertina wire and tampered.
He left. Yes, Lordship.
Then this fellow has to be at home.
Very difficult.
This is not
this is
crime against society alone, crime against nation, especially taking into consideration the place of posting. And where is the copy of the you filed your affidavit in opposition?
Yes, Lordship.
Show that.
Lordship. That has been announced.
Page 126.
Lordship.
No.
No, Lordship. 103, Lordship. No? It starts from page 103. It's paragraph 5 onwards. From page 104, Lordship.
So he concealed his arrest by the civil
He
police.
was in custody.
When did he join service?
My lord, in the year 2000. My lord, I shall check. Yes, my lord, in the year 2001.
10 years.
Lord, if I may also make one small submission.
That second show cause notice point is no longer available.
No.
My lord, however, my lord, he was acquitted from the FIR that was, my lord.
But what we can do is, under your regulations, there is a remedy of memorial or something is there. We will give you liberty to. That's the only thing we can do. What is that provision?
I'll just.
Did you exhaust all the remedies?
Yes, he exhausted all the remedies. The revision is also there.
Revision is also there.
Yes, he's exhausted the revisional remedy also. The memorial is not available here, Lordship. Reservation.
Please see page section 30.
Lordships.
That is petition.
No, it rules, yes.
Rules, rule 30, Lordship.
That's petitions.
Petitions, that is because 29 revision is exhausted. Then comes rule 30, Lordship.
Rule 28 deals with appeals. Rule 29 deals with revision.
He's exhausted all, both.
Yeah, dismissal is a removal from service because of the explanation in 27.
Yes, sir.
Alright, we'll give some liberty. This intra-court appeal by the writ petitioner is directed against the order dated 19/12/2019 in WP number 21809 within bracket W of 2011. By the said order, the writ petition filed by the appellant was dismissed. The appellant was a constable in the Central Reserve Police Force within bracket CRPF. The appellant came to adverse notice, which led to issuance of a charge memorandum dated 5th November 2008. No, 21st March, I think. Page 52. 21st March 2009, containing 2 articles of charge. The first being that he committed an act of neglect of duty/misconduct in his capacity as a member of the force under section 11 within bracket 1 of the CRPF Act 1949, and he deserted the camp on 13/11/2008 within bracket 4 at his own without prior permission of the competent authority and without any information which is prejudicial to good order and discipline of the force. The second article of charge was that the appellant, while functioning as CT/GD, both capital, at unit headquarters/38 Battalion CRPF within bracket Kashmir, committed an act of indiscipline in his capacity through illegal way by tampering with the defense or camp and endangering the security to the camp. The statement of imputation was furnished along with the list of documents in support of the charge and the list of witnesses which the prosecution sought to examine. Subsequently, an inquiry officer was appointed and a departmental inquiry was conducted and the charges were held to be proved. Due opportunity was granted to the appellant to submit his reply. As could be seen from the order passed by the disciplinary authority, the appellant / delinquent pleaded guilty to the charges framed against him. The appellant preferred an appeal before the appellate authority, which was dismissed, and also filed a revision before the revisional authority, which was also rejected. Challenging the same, the writ petition has been filed. The learned writ court has elaborately considered the grounds which have been canvassed. The learned single bench rightly took note of the fact that the disappearance of the appellant from the camp without permission and recording of second FIR, disclosing a cognizable offence under the Indian Penal Code, has deepened the charge of desertion. Furthermore, the learned writ court took note of the fact that the appellant was arrested by the local police in connection with the second FIR, thereby attracting the charge of committing illegal acts, transgressing the call of duty of a member of a disciplined force. After considering all the points, the court after considering the grounds which are canvassed, the court took into consideration the decision of the Honorable Supreme Court in Divisional Controller Karnataka State Road Transport Corporation versus M.G. Vittal Rao. It is there in page 5 of the impugned order, writ order. Versus M.G. Vittal Rao, 2012 1 SEC 442. Wherein one of the aspects which was dealt with was regard to the loss of confidence of the employer on with an employee. Apart from that, the learned writ court also took into consideration as to what is the degree of trust and confidence a member of a disciplined force has to exercise. And took note of the decision of the Honorable Supreme Court in Samar Bahadur Singh was a state of Uttar Pradesh, 2011, 9 SEC, page 94. Wherein the court, wherein the Honorable Supreme Court has observed that even assuming there was an acquittal in the criminal case, it shall have no bearing or relevance to the facts of the department proceedings, as the standard of proof in both the cases are totally different. Above all, the appellant was a member of a disciplined force and he was serving in a camp at Kashmir. He did not report back to work, did not choose to reply to the memorandum of charges within the prescribed time, and also pleaded guilty during the inquiry. Therefore, we find no grounds to, thus we find that the learned single bench has elaborately considered all aspects and declined to interfere with the order of punishment imposed on the appellant. We find no justifiable reason. We find no grounds to interfere with it.
Grateful.
Next.
Number 3.
I am appearing on behalf of Union of India.
My lord, I am appearing for the appellate side. My lord, I am for appearing for the appellate side. My lord, first of all, my lord, my case is for the hearing stage, not the admission stage, my lord.
Admission, hearing, everything on.
Okay, my lord.
Because
My lord.
intra-court appeal, clause 15. Clause 15 doesn't mean first appeal.
Oh, my lord.
3 days, 4 days, no. Prime facie, you make out a case, yes. Otherwise, gone.
My lord,
Clause 15 appeal, admission is not automatic. Yes, sir.
My lord, senior advocate, Mr. Madhusudan Madhusudan Dutt got the cerebral attack, my lord. My lord, cerebral attack. My lord, need some time, my lord. This is the medical report, my lord.
No. We'll believe your statement. It is submitted that the learned advocate appearing for the appellate.
My lord, after vacation, my lord.
Has suffered a medical setback and adjournment is sought for. List the matter on. You give a date after vacation.
My lord, item number 30, my lord, same submission, my lord.
Item
number 30.
Let it reach. You be here.
My lord.
Air conditioning is good.
Much obliged, my lord.
Poor my lord, answer to respond.
Lordship, I am led by Mr. Firdaus Samim, sir.
My lord, I am appearing in this matter, my lord. I am representing state respondent, my lord. Earlier, this matter has been taken up by your lordship, my lord, on 24th of February 2025. And the matter has been released because of the want of determination. The matter relates to Group 6, my lord. Thereafter, the matter has been listed before court room number 11, my lord, where we have prayed for compliance of your lordship directions to cover the copy of the application, my lord. I think this matter has been listed wrongly, my lord.
All right, now we have got determination. We'll take it up. We can allow you to amend the presentation form. No problem. You please tell us what is the matter.
But I am for the state, my lord, in this matter.
Yes.
Lordship, my senior is engaged in Supreme Court. So seeking.
That's the best opportunity for you.
Sir, praying for not this week.
No. You open the brief. Let us see. He'll be very happy. You will get an order here. He won't be able to get an order there. Start.
Lordship.
Someday you need to start, no? The best time to start is on the date of enrollment. When did you enroll?
March 2025.
Sufficiently senior. You don't know anything about the matter. What is this matter, sir?
Well, the petitioner before lordship, was appointed as a lab technician. It was purely a contractual appointment. Now, at the time of his appointment, it was specifically mentioned that it has to be the diploma or degree has to be recognized by the state or the central government. Now, subsequently to his appointment, it was detected that the diploma obtained by him is not recognized. That is why.
When did you discover this fact?
It was discovered, my lord,
when he was about to retire.
On a subsequent date at page 57, my lord. That is on 9th.
Some fellow would have dropped
a year, my lord.
Dropped a letter saying that this man, Saptarishi Ghosh, Human Resources, none of the three institutes have ever been affiliated.
Well, this third one, kindly consider the subject, Council for Advancement of Medicines in Alternative Process, second ICO PMS, West Bengal and Indian Medical Association. Now, the petitioner, my lord, obtained his diploma from this Indian Medical Association. Now, this letter says this was issued by the Secretary of State Medical
Sir,
Faculty.
how many cases of fake certificate you yourself have appeared for the state?
Yes.
Fake certificates. SC fake certificate. Writ petition was filed. Report called for 200 certificates cancelled. Fake engineering colleges. Fake pharmacy colleges.
Yes. Well, this is not a fake certificate, but this certificate obtained by him is not recognized by the state. Now, your lordship will find page 58, that is the part of that advertisement. Kindly see, this is NACOTOR, that means
page
58, the next page, This NACOTOR means National AIDS Control Organization, and it is a terms of reference. Now, the left-hand side, my lord, your lordship will find that the post has been mentioned blood bank lab technician. Then thereafter, under the second box, essential qualification, degree in medical laboratory technology or diploma in medical laboratory technology. Then, my lord, kindly skip over the next 3 lines. Then degree or diploma should be from a university or institution recognized by the central government or state government, my lord. Now, the, my lord, diploma, my lord, which is at page 46, my lord. This was, my lord, obtained from Indian Medical Association, my lord. This Indian Medical Association is not a recognized body. And, my lord, that, my lord, I have.
Now, you referred to one letter.
Yes, page 57, my lord.
57.
Yes.
This is from West Bengal.
Yes.
This diploma is issued by an organization at
this
New Delhi.
Indian,
probably they have a recognition
my lord,
there.
I filed a report, my lord. Your lordship will find from the judgment that report has not been annexed. I filed a report, my lord, in the.
Sir, Indian Medical Association is a recognized body.
Well, this Indian Medical Association is perhaps, my lord, not the Indian Medical Association, your lordship.
IMA, it's not that IMA.
No, no.
Oh, but it says recognized by the government of West Bengal, Department of Health and Family Welfare.
Yes. This is not.
Two-year course training in theory of practical of medical lab technology conducted of Society for Zone Kolkata. Passed his qualifying exam conducted by the Indian Medical Association. President, Paramedical Course Chief Coordinator, Dean Paramedical Courses, Honorary Secretary General, Indian Medical Association, Dr. R.N. Tandon, New Delhi.
Yes.
Sir, I think it should be the Indian Medical Association at New Delhi. Probably this course was done. Otherwise, the Secretary General will not sign. Where is your writ petition? Whenever you come, always carry the brief. That's where you start learning. Please tell your clerk, please give me the brief, I will go through. Okay.
Well, the writ petition is at page 22 of the stay application.
রিপোর্টটা আছে যেটা আমরা দেখছি এটা কপিটা মানে এমনিও পাঠাইনি
Sir, after this, after verification, he was allowed to participate in the written test, computer test, oral interview conducted by the CMO, Puram Bardhaman, and finally was selected.
Yes.
Sir, unreasonable.
Joining it actually, they joined also.
He joined in 2018. And what is the reason given by the learned single bench?
Well, at page 59, on the basis of the letter, my lord, dated 9th March 2018 at page 57, my lord, the joint director, my lord, wrote a letter to the CMO at page 59. My lord.
No, his case itself was this Indian Medical Association had a recognition from the government of West Bengal. Its head office is in New Delhi. The other state governments have recognized. Forget all that. He produced his credentials. Credentials were verified. Then he was permitted to sit for the written test, or a computer test, oral interview. Thereafter, he was selected. And he appointed.
State, my lord, filed a report in the form of affidavit, my lord.
Let us
That
see.
report is not, my lord, here, my lord, that has not been annexed.
You show the report.
The report is not with me, but my lord, this has been referred to, my lord, at page 67 in the judgment, my lord.
Suppose they had obtained recognition from the government of New Delhi. That is enough. It doesn't say state of West Bengal, central government
Or state government, any state government.
any state government. Where is the termination order?
My lord, the termination order is at page
Without show cause.
page 60, my lord. Yes.
Without show cause.
Yes, ma'am.
Nothing. Please come. This intra-court appeal.
My lord, in this matter, my lord, I am led by Mr. Firdaus Shamim. He is
We'll
engaged in
dismiss your
Supreme Court.
appeal.
My lord, kindly.
We will dismiss your appeal. Basic things is art of advocacy. You have to observe what the court is observing. You are talking to him. He doesn't even have the brief. Who are you in the matter?
I'm junior.
First of all, learn how to represent. You see what's happening in the court. What are the observations from the court? Whether the court is inclined towards you.
My lord, sorry, my lord.
This is the first time you are appearing before me. Have you appeared in court number 16 when we had group 6? No. When you do a service matter, you have to be attentive to what the court asks, what the court observes. If you don't learn now, he will never learn. This intra-court appeal by the writ petitioner is directed against the order dated 28/7/2023 in WPA 12079 of 2019. The writ petition was filed challenging a memo issued to the appellant writ petitioner dated 4th of April 2018, issued by the Chief Medical Officer of Health, Government of West Bengal, Purva Bardhaman. By the said communication, the services of the appellant, who was appointed and serving as laboratory technician, was terminated with effect from 5th April 2018. Initially, the appellant approached the West Bengal Administrative Tribunal by filing OA number 525 of 2018, which was dismissed on the ground that it was not maintainable before the learned tribunal, giving liberty to the appellant to move the appropriate forum, ventilating his grievance. Therefore, the appellant approached this court and filed the writ petition, challenging the order of termination. The learned single bench, by the impugned order, dismissed the writ petition and agreed by the same. The appellant has filed the present appeal. What is your name? You write both of your names. You are also in the same office?
Yes, Lordship.
You give your name. You have given?
Given, but
What is your name?
Shoikat Mullik. Shoikat Mullik.
Soikat?
Mullik.
Payal Shom.
Right, both of you.
Yes,
We have heard so and so and so and so and so. The appellant had undergone a diploma in medical lab technology course from the Indian Medical Association with its headquarters at New Delhi. The course was conducted by the Society for the School of Medical Technology, Calcutta, which is recognized by the Government of West Bengal, Department of Health and Family Welfare, and having Clinical Establishment Act registration number HF/0/MS/252/4 capital C -04/2002. From the statement of marks, it is seen that the appellant scored an aggregate of more than 40% in all the practical and theory papers and successfully completed the course. The statement of marks have been duly signed by the Dean of the paramedical courses, IMA, by the Chief Coordinator paramedical courses, IMA, and the Indian, and on behalf of the Indian Medical Association within bracket HQ, New Delhi. A diploma certificate was also issued to the appellant, which has been signed by all the above mentioned officials, including the as well as the Honorary Secretary General, Indian Medical Association at New Delhi. The diploma was secured by the appellant on 18th November 2017. The respondent, namely the Chief Medical Officer of Health, District Health and Family Welfare Samiti, Purva Bardhaman, issued a notification dated 13th April 2017 for recruitment of contractual employment engagement under WBSAP and CS, I don't know what it is, Purva Bardhaman, and the post, one of the posts being the post of lab technician. The number of vacancies were 3, out of which 2 were for unreserved and 1 for scheduled caste. The monthly consolidated remuneration was fixed at rupees 13,000. The eligibility criteria as contained in the notification states the degree in medical lab technology within bracket MLT or diploma in medical lab technology within DMLT should be possessed, semicolon, should have completed 10+2 before obtaining diploma or degree, semicolon. The degree or diploma should be from a university/institution recognized by the central government or state government, semicolon. The candidate should be registered with the concerned paramedical council if applicable and knowledge of computer. The appellant applied for the said contractual appointment and upon scrutiny of the appellant's credentials and being satisfied with the same, an admit card was issued for the written test, computer test and interview for recruitment to the post of lab technician. The written examination was conducted on 17/11/2017. The computer test was conducted on 23/11/2017 and the interview was conducted on, written test was held on, computer test conducted on, interview held on 24/11/2017. The appellant was found to possess the requisite qualification and was selected, and an order to the said effect was issued on 8/1/2018, by which the appellant was posted as blood bank lab technician in Katwa, SDH. The appellant joined the said post on the very same day, namely 8/1/2018, and on 9/1/2018, and the joining report has been duly endorsed by all the authorities. The superintendent, Katwa SD Hospital, Purva Bardhaman, has issued a certificates certifying that the appellant is working at Hemraj Blood Bank, Katwa SD Hospital as lab technician within bracket daily basis, bracket close, from 1st April 2013 till the date of issuance of the said certificate, and his performance at Katwa SDH is excellent and very much satisfactory. He is well behaved, laborious, well behaved, not laborious, obedient, and he wished him success. After a considerable period of time, there appears to be a communication sent by the Secretary of the State Medical Faculty of West Bengal to one Saptarishi Ghosh, Human Resource Officer, Department of Health and Family Welfare, West Bengal State AIDS Prevention and Control Society, Calcutta 91. In the reference column, 3 institutions have been mentioned, namely Council for Advancement of Medicines in Alternative Process, 2, ICOPMS, West Bengal, and 3, Indian Medical Association. The said communication states that none of the 3 institutes have ever been affiliated by the State Medical Faculty of West Bengal, nor have the diploma certificate in DMLT course as issued to different candidates by the institutes. And this appears to have been the basis for issuance of the letter of termination dated 4/4/2018. In our considered view, the letter of termination is flawed and unsustainable in law for several reasons. Firstly, the appellant was not afforded any opportunity by way of a show cause notice or in the form of a charge proceedings before action was taken. Secondly, the appellant was not furnished with the copy of the communication sent by the State Medical Faculty of West Bengal to the West Bengal State AIDS Prevention and Control Society, which appears to be the basis of the termination of his employment. Therefore, these two will clearly show that the order of termination is in a violation of principles of natural justice and illegal. The second aspect is that the letter sent by the State Medical Faculty of West Bengal states that the Indian Medical Association is not affiliated by the State Medical Faculty of West Bengal. This is not a requirement for being eligible to apply for the lab technician course, as the degree or diploma should be from a university or institution recognized by the central government or state government. Prima facie, it is clear from the certificate that the institution is recognized by the Government of West Bengal, Department of Health and Family Welfare, and the relevant details have been given. Apart from that, the association has its head office at Delhi. Therefore, the communication from the State Medical Faculty of West Bengal could not have been the basis for termination of the appellant's employment. And thirdly, the appellant had been working on daily wage basis from 1st of April 2013 and has been found to be fit and excellent in discharge of his duties, and his behavior was also certified to be good by the superintendent of the Katwa SD hospital. Thus, for all the above reasons, we are of the view that the order of termination of his contractual employment with a order dated 4/4/2018 is unsustainable law and calls for interference. Accordingly, the appeal is allowed. The order passed by the learned by order dismissing the writ petition is set aside. Consequently, the writ petition is allowed, and the appellant is directed to be reinstated in service as a lab technician in any vacant position in Pura Bardhaman district on the same terms and conditions which not I'm saying, because by now it's supposed salary is increased on contractual basis. If there are no vacancy available in what is this place he was working? No. Katwa SD hospital. Then in any other neighboring hospital or blood bank, the appellant shall be appointed. This direction be complied with by the appropriate authority of the respondent within 3 weeks from the date of receipt of the server copy of this order. However, during the period when the appellant was out of employment, he shall not be entitled for any wages. Charge me more. What do you charge me? We have come to the conclusion that the order of termination of his contractual employment to be unsustainable on the ground that the appellant was not given an opportunity, as there is an imputation against the appellant. Assuming it is a termination of service simpliciter, a stand can be taken that a formal charge memo or a show cause notice is not required. If there is an imputation against an employee, it goes without saying that the employee is entitled to an opportunity before any action is taken against. Without brief, without opening his mouth, he has succeeded in one matter.
My lord, kindly recorded one line, my lord. Petitioner prays for. Use your mic.
Be loud, madam.
My lord, kindly recorded one line. Petitioner prays for time. I know.
Hey, when did you enroll, no?
Don't be agitated. I am making her understand.
No, today also. Huh? You didn't hear what we said.
She is unable to understand.
Unable to follow. What is that?
Then she has to be put under a rigorous senior. She's fighting with the clerk now.
She confused.
Huh? The other colleague of him who enrolled last month, he was able to understand. All 25 minutes of anyway.
Serial number 5.
Malad, I am appearing on behalf of the appellant. I beg to appear on the petitioner respondent. And there is a section 5 application.
You are
that was
opposing.
not allowed.
Dismissed.
No, 425
there is no
delay.
at all.
Reason is, my lord, that yes.
How many days delay?
425 days delay, my lord, because the review is pending due to the pendency of the review, my lord.
All right, Allahabad Bank, subject to payment of cost. To whom? He is your employee?
Hello. Yes. Condonation of delay is no matter of right, my lord. Even 1 day delay should be, my lord, explained.
If you want us, we can record reasons.
But there is
100 pages also.
No sufficient reason has been
So our state legal service authority without money, sir, you pay. Don't ask. Don't.
He's my advocate.
He may be advocate. He will say no. And what was the post he was holding?
Appellant is bank, my lord. Before your lordship. It's a public money.
Public money. How much last year you get the balance sheet? How much amount you was written off by Allahabad Bank. It is merged with Indian Bank.
Now,
That is why it merged with Indian Bank.
yes. Now,
You have to amend the cost title.
now it is Indian Bank. Now it is,
What is the dispute?
dispute is, my lord, the respondent employee suppressed the material fact of his qualification. Though he was passed, my lord, Madhyamik examination, suppressed the fact. He stated that he class 8 passed and got the employment.
But there is one recent decision of Supreme Court which says higher qualification.
No bar.
Higher
But at the same time, my lord,
also our notification says.
my lord, yes.
There is no rule. There is no rule in the field, my lord.
I will also show
That's why, my lord, I am
judgment.
pressing here.
You are
Our
blocking.
special bench judgment, my lord, already clarified
My
the
lord,
same.
yes,
Leena Datta's case.
my lord, I also show the another
appeared.
another Supreme Court judgment where Supreme Court says you are blocking another genuine candidates, my lord.
Contractual. People with postgraduate qualification are applying for the post of
Dome, my lord. Recently, our municipality.
Over qualification is no bar, but whenever you have tried to take entry on the
And
suppressing.
what was the post he was appointed?
He was
The sweeper, my lord. Part-time sweeper, my lord.
Disha. Postman.